verify password.
Hello, how are you? Yeah? How was Miami? Warm. Warm, yeah, I guess so. So still a jet lag from that?
Yeah, well, I had to cross their time.
Yeah. Well, fine, I didn't have a jet lag. Easy going. But did you presentation?
Yeah, I think there were a lot of people just people.
Nee. Oh, well, but still, that's good. Good shape. Sure.
Las monetas. Oh, right, yeah, then you don't have that. Yeah, but that, so they have to make the sense.
Σου έχει αυτό. Οπότε με αυτό λογικά προχωράς. Τις διαφάνειες.
Yes. This is you too. Yeah. Put a face on it. Yes, yes, yes. It's a bit hectic. Hemicycle. Yes, yes. It's behind the ECCL, the European Convention Center. Yes. Okay, no problem. Yeah. Yes. Tomorrow it will be even bigger. Yeah. On the 1st of June we will reach the peak around 200 people. So all of the EPPO will. That's Wednesday morning. Wednesday morning I will be there as well. Yeah.
1, 2, 3, 1, 2, 3, test, 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 test. 1, 2, 3, 1, 2, 3. Bonjour, c'est 30.
Va bien.
Ouais, on voit pas bien la caméra, donc je bouge un peu.
Allez, 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 allez.
David Fernandez from Let's do it. We go to this conference.
So you are moving another. Yeah.
Yes, yes. So I think you're ready. Do I need to push anything?
I think it's already up. Yes.
Okay. And we don't. So I will have also the first panel to come.
Yeah. Take the receipts.
And the first panel is. Shouldn't I sit there? Do they have name tags? No.
No.
Okay. It doesn't matter.
Franzen is not here today.
Okay.
Her co-author will present.
Okay. Okay, I will then just go down. Okay, we close the door and we're good to go.
Yes, I leave the back door open for Theo to come.
Okay.
He will stay a bit for anyone who may be late.
Okay, let me close this door.
Yes. Come on.
Distinguished guests, ladies and gentlemen, a very warm welcome to the University of Luxembourg. It's a great pleasure as Dean of the Faculty of Law, Economics and Finance to welcome you at our premises in person. It wasn't evident that we can have larger events in person in the past, and this is one of the first ones that actually my university is having. I'm welcoming you not only as the Dean of the Faculty, but also as a Professor of European and International Criminal Law, and as one of the participating, so to say, partners of the so-called EULEN network. It stands for EU Law Enforcement. We are starting today a 3-day event on the European Public Prosecutor's Office and the protection of the financial interest of the European Union. We start today with an event which is organized in the framework of the Monnet Network on Enforcement of EU Law, abbreviated as the EULEN Network, which is co-founded by the Erasmus Plus program of the European Union. This EULEN Monnet Network brings together 9 universities from 8 European countries to address different law enforcement challenges across different policy areas of the EU. And the network is coordinated by Utrecht University, and I am particularly pleased and happy to welcome here the actual coordinator of the network, Professor Michiel Luchtmann. The network examines challenges of enforcement in different policy areas, going from banking supervision to border controls, migration, asylum, to the protection of the financial interest of the EU. And the University of Luxembourg, as a partner of this network, is responsible for the thematic area of the protection of the Union's financial interest, with a focus particularly on fight against offenses affecting the Union budget. We all know that the PIF sector, the so-called PIF sector, we all know the abbreviation stands for the protection of the financial interest of the EU, has gained a lot of momentum in recent years. It has always joined a certain special status within the Union policies because it concerns the protection of a legal interest that pertains to the EU as such. The budget has been defined as an institutional, sometimes supranational, sometimes even a quintessential interest of the Union. For its uniqueness, the PIF sector has always been a sort of laboratoire juridique for the development of enforcement, especially in the criminal justice field. A testament to this importance of the enforcement of the budget of the Union is actually the establishment of the European Public Prosecutor's Office, which is now entrusted to investigate and prosecute these offences. It's the first EU criminal justice body which has a unique and uniform, so to say, powers vis-à-vis the individuals in the field of criminal justice. In December 2021, we launched a call for papers. We were seeking for original contributions to analyze the latest developments and challenges across 3 levels of EU norms of enforcement in the PRISP sector: decentralized enforcement, transnational enforcement, and supranational enforcement. We were very lucky. We have received lots of papers, and we made a very rigorous selection process with the help of the network coordinators. And we were lucky to select a large number of papers that we will be listening to today. Actually, on the EULEN network's webpage, the papers have been already published, so you can all access and read the papers. And today we have the possibility to discuss with the papers' authors and to have a lively debate. The topics cover, so to say, a range really of topics, from national recovery and resilience plans to gathering of evidence by the EPPO. At this point, I would like to thank for all the speakers of this afternoon's panels, as well as to all of those colleagues who have accepted to chair one of the panels, particularly to Professor Frank Meyer, to Professor Silvia Allegrezza, and to Professor John Fefale. I look very much forward to the fruitful discussions that we are going to have this afternoon, and I would like to invite the chair of the first panel, as well the speakers of the first panel, to join, so to say, the table. And without further ado, I also hand over to the chair of the first panel to introduce the speakers of the first panel. Thank you very much. It's here.
Ladies and gentlemen, thank you very much, Katalin, for hosting this event and attending this event in so large numbers. It is, of course, a privilege to host this first panel, which will bring many interesting new insights and a number of highly interesting presentations. As Katalin has just said, this first panel is part of the EULEN network, which we have substructured according to the various enforcement models that we have identified as part of this network. And the first panel will deal with what we call decentralized enforcement. You will all know that this is a rather broad category. If you look into the details of the enforcement models that we have found so far, that we have identified and tried to decipher, it will prove that it's just a very general, abstract category with lots of subtleties and lots of differences. And the presentations that we will hear today will just underscore the diversity that we see in this subcategory. On that note, my applaud goes to the organizers, which have chosen very carefully very different examples of decentralized enforcement that tell a story about how rich the landscape is in this area. As I've already said, the necessity to enforce EU law effectively has spawned very different models, and we will see three different perspectives on these models. First comes Nicola Ruccia, who's associate professor at the University of Benevento. He's an expert in European law, and he will talk about perhaps the most important aspects of Next Generation EU, the Recovery and Resilience Facility. He will present a study of national implementation programs, national approaches to implementing this facility. We'll try to compare them and also give us some first ideas of the activities that we can expect from Olaf and the EPPO in this area. Very interesting and complementing the first presentation is our second presentation from Emanuele Meritieri, who hails from Luis University in Rome, where he is a postdoctoral researcher and where he specializes in criminal law, in particular economic criminal law, anti-money laundering, also anti-mafia legislation, if I understood it correctly. He will look specifically into the Italian model of the implementation of the resilience and recovery program, and will present a specific Italian approach, the so-called, what he calls a new approach, cooperative compliance, which has been built into the national program, and it could be an interesting case study for a bottom-up approach. As we leave in the decentralized model, many decisions, important decisions to the national level, how certain EU requirements are implemented, how they are enforced. It deserves a closer study, close scrutiny, what national authorities do and what specific approaches do they develop, what works, what doesn't work. And it would be very interesting to hear from you whether this idea of cooperative compliance is something worth copying, perhaps, or worth adopting in other countries in the European Union. And third, expressing or targeting another crucial aspect of decentralized enforcement is Anna Klaes, sitting to my left side. She co-authored a paper with Vanessa Franzen. She is not yet a postdoctoral researcher, but already an established researcher and a lawyer at the University of Liège. And as a lawyer and researcher, she has a special expertise in customs law, and this is also a specific angle that she brings in here. So what she will present us is a case study, or the Belgian case, how the regulations of the EPPO have been implemented in Belgian law with respect to the cooperation between the EPPO and the customs authorities. And I told her already that I very much like this idea to talk about the customs service, because this is perhaps an agency that is very often overlooked. In many jurisdictions, the customs service is quite a powerful agency with far-reaching competences and a lot of powers in actual law enforcement. And it is worthwhile, I guess, with respect to the specific role of the EPPO, to study customs services a little bit closer, in particular also from an academic perspective, because it brings out this idea of composite structures and hybridity that we see when we combine administrative agencies and law enforcement agencies in the quest of enforcing EU law effectively. On that note, I'll hand the microphone to the first presenter today, Lucia. The floor is yours.
Thank you. Switch on this presentation. It will be the next slide. You just have to click? Yes.
The next one. Okay.
Thank you very much for the organizers of this very interesting conference. Thanks to Katalin and thanks to Frank for the presentation. Some brief remarks about my topic. What is Next Generation EU? It is the most important response to the economic problems generated by the COVID-19 pandemic. And the resources of the Next Generation EU are designated to relaunch reforms, investments and growth, and supporting the modernization of the European Union, especially through the climate and digital transition. Next Generation EU has been implemented throughout a regulation. This is 2021-2041 of the European Parliament and of the Council. And this is the Recovery and Resilience Facility regulation. The most important thing in this regulation is that resources are raised by the Commission in the capital markets, and funds are shared between the member states in relation to structural and contingent reform variables. Structural such as population, and contingent such as the loss of GDP. Next Generation EU has been implemented in the member states through the national recovery and resilience plans. Each of them have been endorsed by the European Commission and approved by the Council. Then member states will receive the accorded financial support divided in loans and grants, and this support is subject to the implementation of reforms and investments outlined in the singular national recovery and resilience plans. Next Generation EU has been promulgated with the aim of ensuring that the EU's financial interests are adequately protected. Next Generation, the regulation poses a set of questions concerning the protection of the EU financial interest. The first one is about the management mode for the measures to be implemented in order to protect the EU financial interests. The different management modes are provided in Article 62 of the financial regulation. We have three different methods of budget implementation. The first one is the direct management method, direct management by the Commission departments and Union delegation. The second is the shared management with the member states, and the third is the indirect management by entrusting budget implementation tasks to certain EU entities, member states, organizations, and third countries. Differently from this imposition, Article 8 of the regulation establishes that measures shall be implemented by the Commission in direct management. But there are many differences in comparison to the other programs run under the direct management method. The most important concerns the nature of the beneficiary. While this is, in general, a natural person or an entity, including private enterprises, in the regulation, that is a member state. The second difference concerns the balance of responsibility between the member states and the Union in the protection of the EU's financial interests. Formally, Article 22 of the regulation assigns the task of the protection of these interests to member states. Actually, paragraph 1 provides that member states shall take all the appropriate measures to protect the financial interests of the Union and to ensure that the use of funds complies with applicable Union and national law, in particular regarding the prevention, detection, and correction of fraud, corruption, and conflicts of interest. To this effect, the member state shall provide an effective and efficient internal control system and the recovery of amounts wrongly paid or incorrectly used. then member states may rely on their regular national budget management system. Then, this rule clarifies the responsibility of member states above and beyond the implementation of the measures, providing them the specific obligation to protect the EU financial interest in their entirety. It also identifies national control systems as the main instrument for the safeguard of the EU in financial interest. And this is a second important difference, because Article 325 of the Treaty of the Function of the European Union assigned tasks to the Union. Then, with regard to the next generation EU, the task, on the contrary, is assigned to states. Article 22, paragraph 2 establishes specific tasks for certain EU bodies. Then we can imagine a shared competence between the Union and the Member States. Actually, Member States have the duty to expressly authorize the Commission, OLAF, the Court of Auditors, and where applicable, EPPO, to exert their rights and to impose obligation on all final recipients of funds paid for the measure for the implementation of reform and investment projects included in the Recovery and Resilience Plan. Then the regulation confirms that the competence of EU control and investigation institutions and bodies applies to the explicit and specific conferral of powers set up for the purpose. Within this ambit, it refers to the principle of cooperation for the protection of financial interests of the Union enshrined in Article 129, paragraph 1 of the Financial Regulation. It consists in the need to expressly authorize in financial agreements the power of the Commission, OLAF, the Court of Auditor, and EPPO to exert their own competencies. The third question posed by the regulation concerns the concept of serious irregularity. In this definition, an important contribution is provided by Recital 53 of the EFR regulation. Fraud, corruption, and conflicts of interest in relation to the measure supported by the facility. This definition makes it possible to overcome an old dichotomy between criminal and administrative profiles of conduct used in other acts relating to the matter in question, such as in the annual report of the protection of the EU financial interests. These reports are generally limited to the distinction between fraudulent irregularities and non-fraudulent irregularities. In general terms, cases of fraud and corruption could fall into the criminal category, while conflicts of interest should be included in the administrative category. In any case, this tripartition of categories in the next generation regulation is brought back to unity, and the commission of one of them implies the same responsibility. As a result, member states are supposed to lay out in their national plan their system to prevent, detect, and correct serious irregularities, regardless of the category in which they are included. And the Commission, in turn, shall assess the efficiency of the national plan, evaluating the measures outlined in them. Furthermore, it can reduce proportionality, the financial support, or ask for early repayment of the loan in case of fraud, corruption, and conflict of interest, affecting the financial interests of the Union that have not been corrected by member states. And this is the application of the principle of proportionality enshrined in Article 5, paragraph 4 of the Treaty on the European Union. The fourth question refers to the collection of data provided in Article 22, para 2, letter D. It contains an explicit requirement for member states to collect certain of them, such as the name of final recipients, contractors, subcontractors, and beneficial owners of the next generation expenditure. This constitutes a true and significant novelty compared with previous rule, and this has been introduced in accordance to the method follow the money, which is nowadays crucial in financial investigations. An important innovation in the protection of the EU financial interests contained in the Next Generation Regulation is the drafting of national plans in advance of the disbursement of funds. In the light of the performance-based nature of the mechanism, their main objective is to describe and develop the predicted reform and investments, including corresponding milestones and targets. Anti-fraud measures must also be analyzed under the same mechanism. Indeed, the national plans must contain the definition of the respective proposed system to prevent, detect, and correct serious irregularities, as well as the arrangements taken in order to avoid double funding from both the facility and the other EU programs. The Commission subsequently assesses the measures outlined in each national plan and does the same before each disbursement. Through this competence, the Commission also fulfills its task of performing an ex-ante check of the Member States audit and control system within the ambit of the ERRF regulation. Furthermore, are in accordance with Article 2.10 Annex 1 of the regulation, the Commission for the assessment of the national plan shall take into account whether the internal control system described in them is based on robust processes and structures and identifies clear actors, bodies, and entities, and the respective roles and responsibilities for the performance of the internal control task. It also takes into account whether control system and other relevant arrangements described in national plan, in particular to prevent, detect, or correct corruption, fraud, and conflicts of interest, are adequate. As a result, when a national plan fails in the evaluation at issues with regard to the audit and control performances, it fails in its entirety and therefore transversally in compliance with the principle of proportionality. Olaf played an active role in providing anti-fraud advice to the relevant Commission departments and the national authorities in the preparation of the pertinent chapters of the national plan. In particular, it has provided its input on whether the control and audit mechanism established in them had the adequate solidity to protect the EU's financial interests, with the aim of ensuring that the measures were as effective, efficient, and operational as possible. It also had a significant role in the screening and assessment of the national plan. So far, 24 national plans have been adopted. This confirms that in general they have included audit and control arrangement in their respective national plan, which transpose the specific provision of the RRF regulation. The measure to protect the EU financial interest have been the subject of a first experimental phase of use, corresponding to the verification by the Commission of the fulfillment of a group of milestones and targets reflecting progress on reforms and investments. Indeed, upon completion of the relevant agreed milestones and targets indicated in their national plans, the Member State will present a request to the Commission for a disbursement of financial support. Within this phase, OLAF fulfills its mandate by carrying out administrative inquiries into the expenditure incurred in implementing the measures provided for in the national plans. Olaf will also provide financial support to member states for the implementation of anti-fraud measures through a specific funding instrument, the Union Anti-Fraud Programme. In addition to the traditional activities concerning the protection of the EU financial interest, further activities will be needed to guarantee these interests with specific respect to the RRF regulation. To this end, a major work of Olaf aimed at cooperation with national authorities and its partners at EU level, such as Europol, and where appropriate EPPO is desirable. The possible reform of this cooperation are manifold. For example, based on past share management experience, Olaf should support the Commission services in relation to the expenditure by continuing to carry out dedicated anti-fraud advice on member states' management systems. Last slide. Since the EPPO started its activity exactly 1 year ago, it was not possible for it to contribute to the scrutiny of the Commission of the individual national plans. Even with reference to the analysis concerning the first requests by member states for disbursement, which took place last winter, its work was still quite marginal. However, this does not prevent us from reflecting on the impact that its activity could have on the implementation of national plan and on the protection of the EU financial interest, especially if one observes the close relationship between EPPO and Olaf. The first one has specific and significant tools to carry out its investigative mandate, but it must necessarily rely on the competent national authorities to prosecute wrongdoers. The EPPO, on the other hand, has the power to investigate and prosecute wrongdoers through the European delegated prosecutors appointed by the participating member states. Given the common objective of EPPO and Olaf and their potential overlap, the regulation established in the EPPO expressly directs it to establish and maintain a close relationship with Olaf, based on mutual cooperation with their respective mandates and on the exchange of information. Their relationship is founded on the use of all available means to protect the EU financial interest through the complementarity and the support of EPPO towards Olaf. In order to promote coordination of individual operations, 2 years ago it was necessary to amend the Olaf regulation. Parallel to the EPPO regulation, the Olaf regulation, as amended, provides in the relevant part that Olaf will work with EPPO to ensure the highest level of protection of the financial interest of the Union through synergies between them, while ensuring close cooperation, information, exchange, complementarity, and avoidance of duplications. Finally, the legal framework of the ERRF regulation to protect the EU financial interest seems to be solid. Member States, as beneficiaries or borrowers of funds, have the duty of identifying and correcting all irregularities, especially serious ones such as fraud, corruption, and conflict of interest. Consequently, the Commission, with the contribution of Olaf, has also positively assessed the national plans, and furthermore, the management and the control system of the Member State will be supported and complemented by the joint activity carried out by the EU institution and body. It is clear that no authority can individually assume the burden of protecting the EU financial interest related to the RRF regulation, but as structured, the Olaf and EPPO present a potentially formidable force to reckon with it in the fight against fraud affecting the EU financial interests. And thanks for your attention.
Thank you very much, Nicola, for a very interesting first presentation, a very interesting case. on how complex a cooperation framework this regulation includes itself. We have agreed with the speakers beforehand that we'll hear all three presentations in turn, and then afterwards have the opportunity to take questions from the floor with regard to all presentations. So on that note, I would give the floor to Mr. Bellatieri, our second speaker. I was wondering, is it better if he speaks from there? Perhaps?
Yes.
Yes.
Or we can probably adjust the ring. The rack is.
It's only if you are too close to the microphone.
Okay, thank you. Can you hear me? I think yes. Okay. Thank you, Professor Meyer. Thank you also, Professor Ligeti, Panagiotis, all the organizers, for giving me the opportunity to speak here. It's really an honor for me. I have to say that today I'm presenting also on behalf of Dr. Tati, my colleague from Louis, who co-authored the paper with me. My intervention will focus on cooperative compliance measures to prevent organized crime infiltration into the legal economy and protecting the EU's financial interest. I will split my speech into three parts. First, I will give an explanation explaining why I'm talking about anti-mafia measure in the context of a conference concerning the EPPO and the protection of EU financial interests. Then I will give you an overview of this cooperative compliance measure concerning also the protection of the European Union financial interests by looking also at the general context, I will say, of the Italian anti-mafia code, Italian anti-mafia legislation. And finally, I will address which are, in our view, the strengths and the weaknesses of these non-criminal tools enforcement models in combating crime and in protecting the European Union financial interests. So why I'm talking about anti-mafia in the context of EPPO? Because preventing organized crime infiltration into the legal economy, so public procurement, but also public financing sector, means fighting fraud against European Union financial interests. Because if we prevent criminals from entering the legal economy, the public procurement sector, the public financing sector, actually we are reducing opportunities for crime affecting European Union financial interests. Because in Italy, most of the crimes affecting EU financial interests are committed by mafia and by organized crime. So if we prevent these criminals from entering the legal economy, we are reducing crime opportunity. But how we can reduce this crime opportunity? The point is that in Italy we are no longer do that only using the penal code, the criminal code, the traditional, I would say, criminal investigation and proceeding. But we are doing that also by using administrative, or I would say hybrid tools, preventing criminals from entering the legal economy, that are very useful and that used most than the criminal ones nowadays in the context of anti-mafia, as I will say later. Which are the, I would say, two opposing needs that we have in this context using these non-criminal tools to fight crime? On the one hand, of course, we want to use these tools to counter and prevent crimes, of course, also affecting European Union financial interests and preventing criminals from entering the legal economy, public procurement and public financing. But also we use these cooperative compliance tools in order to avoid confiscation and to avoid interdiction, as to rehabilitate, I would say, companies that are infiltrated by mafia, but then can still come back to operate fully legally. So we want to balance these two different needs. So which are these tools? We have tools adopted on the one hand by the judicial authority, so the criminal court who apply the measure of the anti-mafia code, but also we have tools adopted directly by the administrative authority. So in Italy, this administrative authority is the prefect, who is a local administrative authority. Let's start from the instrument adopted by the judicial authority. The first and most severe measure here is the anti-mafia preventive confiscation. That is a non-conviction based economic measure, actually, with which we in Italy confiscate the companies, the economic asset, for the enterprise that is directly totally controlled by mafia. So if the company is totally controlled by mafia, we confiscate this company using mere circumstantial evidence, but we'll come back on it. If the enterprise is totally controlled by people just suspected for being part of mafia, but we'll come back on it in a second. If the company is not totally controlled by mafia, but just infiltrated by criminals, we use the cooperative compliance tools. So we do not confiscate the enterprise, but we use these two cooperative compliance tools that are the judicial administration and the judicial control. So if the company is not totally controlled by mafia, but just infiltrated, we use these two types of cooperative compliance measure. The first is the judicial administration of the company. So we remove the manager of the company for a maximum period of 2 years. The judicial authority appoints a judicial administrator who runs the company for 2 years and who introduces in this company the cooperative compliance tools to fight the ongoing infiltration and to prevent new ones. For example, it can adopt a cooperative compliance program using the corporate criminal liability regulation and so on. If the criminal infiltration is not at a nice stage, so it's just sporadic, let's say, we do not remove the manager. So we use not the judicial administration of the company, but we apply the judicial control of the company. So it's like a probation, a maximum of 3-year probation, with which we run a public monitoring of this company with the help of a judicial tutor who follows the company, who helps actually the company to fight the criminal infiltration and to prevent new ones, for example, by introducing a compliance program and introducing other internal control measures. So we do not confiscate this type of company. We do not run an anti-mafia interdiction, for example, but using this cooperative compliance tool, we try to balance the need to fight crime with the possibility of the company to keep working with the public administration. So this company can continue to work. On the other hand, we have the measure adopted by the administrative authority, so the prefect in Italy. The first, even here, the most severe measure is the anti-mafia interdiction ban. So if the company is totally infiltrated, I would say, by the mafia, by organized crime, we ban this company from the public procurement and public financing sector. It is possible also for the prefect to apply administration and control, the measure of the administration and control of company, but just if the company is being awarded a public contract. So the measure of the Article 32 of Decree Law number 19 of 2014 allow the prefect to order the public administration or public control of the company, but just if the company has been awarded a public contract, and normally this type of measure only aims at allowing the public work to be completed. So it's a measure applied only in the field of public procurement. The new measure introduced, especially in the context of in 2021, in the context of the implementation of the Italian National Recovery Resilience Plan, is the collaborative prevention. That is also a cooperative compliance tools, because the prefect here can order also a public monitoring that basically has the same content of the judicial control as an alternative to the anti-mafia interdiction. And we will see in a moment why we run this reform in Italy. So, to summarize, we have a sort of pyramidal structure where we have different non-criminal measures whose intensity is directly proportionate to the level of the criminal infiltration in the company. So if the infiltration is at a low stage, we are just monitoring this company, so public monitoring. If the infiltration is at a high level, we have the public administration of the company, so with the removals of manager. If it is possible to rehabilitate the company, as an extrema ratio, we have the confiscation or the anti-mafia interdiction. It depends if these measures are applied by the court or by the administrative authority. All of these measures, so from the mere public control to the preventive confiscation, can be applied regardless of the existence or the outcome of any criminal proceeding for the same fact. So these are autonomous measures from the criminal ones. You can apply this measure even if there is not a criminal proceeding going on, and can be applied, second point, on the basis of mere circumstantial evidence, so mere suspicion that a criminal infiltration is taking place in the company. So you don't need to prove a crime. You just need the mere suspicion that a criminal infiltration is going on in the company. So let's try to understand which are the strengths and which are the weaknesses of this enforcement model. Of course, it is good, let's say, to have a first barrier preventing criminals from entering the public economy, because as I told at the very beginning, it is important to prevent these criminals from entering the public economy because we are reducing crime opportunity. Also, the cooperative compliance tools are really important because they not have a punitive aim, I will say. They not determine any long-lasting negative or punitive effect on corporation, but we are balancing, using these tools, the need to fight crime with the need to protecting European Union financial interests and so on. And this is also positive that the most severe measure of this enforcement model, so anti-mafia confiscation and anti-mafia interdiction, are now applied just as an extrema ratio, so only where it is impossible to otherwise rehabilitate the company using a cooperative compliance tools. So if we can do if we can run other measures. Which are the weaknesses? Of course, the protection of fundamental rights, because basically using anti-mafia interdiction and anti-mafia confiscation, preventing confiscation, you can reach exactly the same result of an ordinary criminal proceeding, but without having to start it, and with a lower standard of proof, because you don't, here we have just mere suspicion, as I told you before. We don't have the standard of proof of the criminal proceeding beyond every reasonable doubts. But the point is that you can reach exactly the same result after corporation, because the sanction in the Italian corporate criminal liability regimes are interdiction and confiscation. Here too we have interdiction and confiscation, but with a lower standard of proof. So this is why the Italian legislator has tried during the last year to reduce the scope of application of confiscation and interdiction by fostering the cooperative compliance tools that I mentioned before, so judicial administration and control, because there we do not have punitive aim of the measures, but just we are trying to balancing the effectiveness of the preventive enforcement system with the protection of fundamental rights by reducing the scope of application on the most severe measure, because there we have many problems in protecting fundamental rights of the corporation and also of the individuals involved by the application of these measures. So I will stop here. Thank you very much.
Thank you very much, Emily, for excellent timekeeping. You could have continued a little bit for my personal taste, because it was a highly interesting presentation, of course, and it makes me wonder how this would work out as a part of the National Recovery and Resilience Plan. Perhaps this would be the first question for our panel afterwards. On that note, already question to Anna Klaas.
Does that give me extra minutes?
I'll be more lenient now.
We have to use the microphone, yeah. Excuse me up front, I have a very loud voice, so if it's too loud for anybody, but I'll try to keep it down a notch. Hello, My name is Anna Laura Klaas. Together with Professor Fransen, who can only join us tomorrow, I've worked on the implementation of EPPO in Belgium for several years now. And today I would like to talk to you about a particular aspect of the implementation of EPPO, namely the cooperation between EPPO and the National Customs Administration. More specifically, I take here Belgium as a case study, since I'm a lawyer in Belgium and I know the specifics of the system, but I'm very interested to hear about the powers of the customs administration in other countries and how they cooperate with the EPPO. Of course, we're here together for EPPO 1 year in action. Everybody here obviously knows a lot about EPPO already, but I will try to reiterate some aspects of it that are necessary for my presentation. So the EPPO is the first EU body that directly applies criminal enforcement and that wants to attain better cross-border cooperation between judicial authorities, but also tax administrations such as the VAT administration and the customs administration. With this direct criminal enforcement, the EU wants more attention for offences affecting the EU budget, which can be divided into two categories. On the one hand, the fraud at the level of expenditure, such as subsidy fraud, but also fraud at the level of revenue, of course. There are three main resources of EU revenue. We have the VAT contributions, which everybody always talks about when they give examples of fraud affecting the EU budget. We also have the EU member states' own direct contributions, but of course also customs duties and anti-dumping duties, which are also a very important part of the EU budget, but often overlooked during presentations or in literature, especially in Belgium. There's not a lot of literature on the customs administration, especially not customs criminal law, so I'd like to talk a bit more about that. It's important also to indicate, of course, as we all know, that the EPPO regulation entails the rules on the functioning of the EPPO, but it's not a full-blown code of criminal procedure. There's also no European criminal court, and it refers to national law on several matters. So it's, yeah, to me and to a lot of academics as well, it's more of a directive in nature than a regulation, and that's why it's important to look at a national law for how EPPO can function within these systems. What I would like to talk to you is first EPPO's competence regarding customs offences, because not all customs offences fall within the competence of EPPO. Secondly, a very brief overview of the Belgian customs criminal procedure. I will try to indicate some important points, but it's a very difficult it's a very difficult procedure which derogates to a large extent from ordinary criminal law. So if anybody has any further question, please ask me during the day, tomorrow, whatever. Then thirdly, I briefly indicate how EPPO conducts the investigation, and then I'll try to fit these two together. I made the exercise with Professor Fransen in theory, and then last year in February, the Belgian legislator chose a different solution, which was kind of a compromise or a present for the customs administration. And then I will evaluate this solution of Belgium in light of the EPPO regulation. So first, EPPO's competence regarding customs offences. Well, Article 22 of the EPPO regulation refers to the PFI directive, of course, and then we see in Article 3C offences regarding other revenue than those arriving from VAT. So that includes also customs duties, of course, and anti-dumping duties. But what kind of offences fall within this definition? Well, these are the so-called fiscal offences, so only offences that give rise to a customs that fall within the competence of EPPO with regard to PFI offences at least. So examples are import or export without declaration, under-evaluation, misclassification of goods, declaration of false origin. Some concrete examples. On the left side, of course, we see tobacco smuggling here, cigarettes hidden in a tree trunk, which is posted on Euronews. And on the right side, an example posted recently on the EPPO's website on the 29th of April, where the EPPO reported to have seized 470,000 euros in financial assets from a company in Vicenza, Italy. And the company had allegedly evaded the payment of anti-dumping and customs duties by falsely declaring the origin of the imported goods as Thailand instead of China. I think it were electrodes. In Belgium, we have a lot of those cases with solar panels, where the company declares the goods as Thai instead of Chinese. What offenses cannot be considered as PFI offenses? Those are the non-fiscal offenses. For example, offenses concerning licenses or prohibitions, restrictions or control measures, breach of seals, and so on. So these are not strictly the PFI offenses. Of course, the EPPO regulation and the PFI directive indicate that the EPPO is also competent on top of these PFI offenses for money laundering involving the profit, in this case from the customs offenses, criminal organizations that are involved in these customs offenses, and of course the inextricably linked offenses for which certain conditions apply, namely that the PFI offense is preponderant in terms of sanction level, meaning that inextricably linked offense, there the sanction level, if it's equal or higher than the PFI offense, then the EPPO will generally not exercise its competence, unless the linked offense has been merely instrumental to the PFI offense. There are certain exceptions to the material competence of the EPPO, which I displayed here. I will not go into detail in order to preserve the time limit. The question can be raised then, what about excise offenses? But because excise offenses often go together with customs offenses. For example, if we have a criminal organization that's involved in tobacco smuggling, we often have evaded customs duties, but also evaded excise duties. Well, excise duties are not considered as own resources of the EU, so they cannot be PFI offenses. So how can the EPPO prosecute these cases? Well, you could think maybe they can be considered as inextricably linked offenses, but that's only possible if the sanction level of the excise offense is lower than the customs offense, and in Belgium that is not the case. For serious excise offenses, it's 5 years. For the PFI customs offense, it's also 5 years imprisonment. So yeah, inextricably linked is no possibility. I've heard during a presentation of the European Prosecutor for Belgium that the EPPO might try to prosecute under the label of a criminal organization. But yeah, we'll see if that will hold in court. Now, secondly, I'll try to briefly indicate some interesting aspects of the Belgian customs criminal procedure, which applies if the EPPO will exercise its competence for these customs offenses. In Belgium, customs criminal procedure is regulated by the General Law on Customs and Excise of 18 July 1977, but its origin dates back to 200 years ago. It's a very old procedure, and not a lot has changed since then. They tried to, but customs administration is very stubborn. I must say that they're trying to reform it now. It was supposed to be planned for this year, but now they already said it's for 2023, so we'll see what happens. It's a very special criminal procedure, very different from ordinary criminal procedure, and it's always been justified by the legislator for its cross-border nature, the technicality of the crimes, the great mobility of the goods, and the large number of persons involved. One can wonder if that's not also the case for other kinds of crimes, such as VAT fraud or cybercrime. But well, that's the justification, and the courts generally have accepted it in Belgium. What is also important to note is there are far fewer procedural guarantees in this system. Well, there are 3 aspects I would like to discuss briefly with you. I'll immediately go to the first one, is the fact that the customs administration in Belgium is the prosecuting authority, which means that it's not just an administration carrying out checks, imposing administrative sanctions. It is also a real prosecuting authority. It investigates, it establishes the the offenses in its reports, and it actually goes to court to request the imposition of sanctions. So it actually wears two hats. First, they're checking you, and all of a sudden, you're in a criminal investigation without noticing it. Well, what does the custom administration do? First, they try to decide if it's possible to propose a settlement. Generally, according to the law, it's not possible if you had the intent to deliberately commit the fraud. But in practice, it's very widely applied, and they try to put everything under settlement, even serious customs fraud. But if it's not possible, or if the conditions are not complied with, then the customs administration can go to court. I don't know if I can point with this thing. No. They can either go to civil court as a customs administration and recover the damages there, the evaded duties, or they can go to criminal court, because in Belgium, any infringement of customs law is criminally sanctioned. So for any infringement, they can go to criminal court. And there, before the criminal judge, they can not only request to impose sanctions, they also are competent to request the recovery of the evaded duties. So they're both the prosecuting party and the aggrieved party there before the criminal judge. There's one exception. They cannot request a prison sentence. This has to be done by the prosecutor, so he briefly intervenes in the process all of a sudden. The customs administration only can request fines, confiscations, the closing of factories, and so on. So all of a sudden there in the process, the public prosecutor is there. He comes to the court hearing and he requests the prison sentence. But that's basically everything the prosecutor does in this scenario. As a consequence, there's a weird interaction between the customs authorities and the public prosecutor. If there's only a customs offense which is prosecuted, then the customs administration will initiate proceedings, request to impose non-custodial sentences. Perhaps the public prosecutor intervenes to request a prison sanction. But if the case entails both customs offenses and offenses that belong to the power of the prosecutor, then we have a more difficult relationship. Then both the customs administration and the public prosecutor can initiate proceedings for their respective competence. It is possible to put them together in the idea of the administration of justice, the proper administration of justice, but this proves difficult in practice, so often they prosecute separately. Another aspect that's important is the fact that the customs administration really focuses on the good, as opposed to the public prosecutor really more focuses on the persons involved or the underlying criminal activity. The public prosecutor will check whether there's a criminal organization involved, if there's human trafficking or not. While the customs administration really wants to get the goods. Why? Because the Belgian state is, of course, responsible towards the European Union to recover these duties, and it's also the aggrieved party, the customs administration. So they have to see that there's a fast and quick recovery of these duties. So what happens in practice often, if they find, for example, illegal production of cigarettes in Belgium, then the customs administration will immediately seize the goods and then possibly afterwards send some information to the public prosecutor. But then, of course, they can't find anything. They can't do secret operations anymore because the customs administration has already intervened in the situation. So this is a rather difficult situation in Belgium. Also, briefly, when the customs administration conducts its investigation, it has very broad powers. Also, in other countries, they can search goods and stuff like other customs administrations. But of course, they have a lot of powers because they are the prosecuting authority as well. For example, within the customs zone, they can search private premises without judicial authorization. There's a very limited possibility to lift a seizure. If your goods are seized, you have to pay the amount equal to these goods. There's also the special evidentiary value of the reports drafted by the customs administration. They are considered as evidence until proven otherwise, while the rule is normally reversed, at least in Belgian criminal law. It's also not sure when your investigation becomes criminal, because it's the same authority who first conducts an administrative check and then all of a sudden suspect you of having committed customs offenses. And the investigation is also particularly secret. There's no formal right to request access to the file or to conduct additional investigative measures. Well, how will the EPPO conduct a customs investigation? Of course, there are 3 stages of the EPPO investigation. First, the EPPO will be informed either by the member states or EU institutions. Of course, also third parties can report a crime. When the EPPO investigation is conducted, the EDP takes up the role of prosecutor. He has to have the same powers of the prosecutor, and he acts under the supervision of the permanent chamber and the European prosecutor. At the end of the EPPO investigation, he sends a report with a draft decision. This will go to the permanent chamber, who will then take the final decision. Also, during the trial phase, the EDP will exercise all the tasks of the public prosecutor. So he will need to request the sanctions, he will appeal a decision, and so on. Well, the question then remains, how can we fit this EPPO regulation, or like how the EPPO investigation is conducted within the Belgian system? This will be very difficult. Of course, the status quo of the customs criminal procedure is no possibility because the customs administration does everything. When the EPPO exercises its competence, it must be in charge. So the customs administration had to lose at least some of its autonomy. Vanessa and I studied some possibilities that were to amend the Belgian legislation. First of all, the power to prosecute of the customs administration, of course, had to be amended. The customs administration actually wanted, and you can see it on top, that there was a customs official who would become a delegated prosecutor. But that's not compliant with the EPPO regulation, of course, because the EDP had to be independent. Article 6 really puts the emphasis on the independence. It cannot accept any external instructions, so a customs official who is still part of the Ministry of Finance as an EDP would be difficult. Also, if he's only competent for customs offenses, how can the EDPs become interchangeable? Or how can the supervising European prosecutor then do the customs investigation? This proved really difficult. So the other option we saw was to end the prosecution monopoly. Of course, then Belgian law had to be amended. And then the question remained, what rules of procedure should the EDP apply? Can he apply the customs procedure, or should he apply ordinary criminal procedure? Both at its advantages and disadvantages. If he applied customs criminal procedure, then we would have one authority with several offenses in one investigation, but applying different sets of rules. That would have been pretty difficult. Or he could instruct the customs administration and they could use the customs law, or they could use ordinary criminal law. There were several possibilities. What did the Belgian legislator in the end do? Well, not much. It was a very small intervention. What did they say? Well, the customs administration maintains its investigative and prosecutorial powers, but it will exercise it under the authority of EPPO. For this, the customs administration could appoint one customs official who would be a designated customs official. So I pasted a picture of a customs official underneath the general structure of the EPPO. He would act independently from his or her administration and continue to exercise the powers given to him or her by the customs law. The EPPO would have the final say, but could only act through this customs official. The customs official would have to inform the EPPO if he does any investigating or other measures. He cannot propose an out-of-court settlement, and at the end of the investigation, he has to make a report and provide a solution to the EDP, who then makes a report and provides to the permanent chamber. So it's just an extra layer that they imposed. The question will be, who will be de facto in charge? Well, according to the EPPO Act of Belgium of 2021, the designated official will still conduct the proceedings and go to court and request the sanctions. But it will do under the authority of EPPO. So the EPPO will give instructions and then the designated official will carry them out. So the EPPO can intervene strongly by holding the designated official tight, close, but the fact is that in Belgium there's a pre-existing great autonomy of the customs administration, and the prosecutors are generally not very familiar with the customs legal framework. So it might be, the result might be that in fact the customs administration still carries out the whole proceeding. The question then can be, is this conform the EPPO regulation? Well, the EPPO will still have to act via this customs official for investigating and other measures during the investigation. I think this is possible because Article 28 of the EPPO regulation provides that the EDP can either conduct investigating measures himself or instruct the administration. So I think that's possible, in my opinion, but we can have a discussion about that, of course. But bringing the case to court and asking for a sentence or the imposition of fines, I think that will be difficult because the EPPO regulation requires the EDP to go to court and ask for the sentences. Belgian law can, of course, be set aside, but in my opinion, it's better to amend Belgian legislation and to provide a sort of advisory role for this designated customs official. And some last notes is also that I think if we leave the customs administration in this strong role, there will be a clash of approaches because the customs administration focuses on the goods while the prosecutor focuses on the people or the underlying activities. So depending on who will de facto be in charge, there will be a different approach unless the EPPO takes another approach in customs cases or the customs administration takes another approach. And furthermore, because there are so many derogatory rules from ordinary criminal law and fewer procedural safeguards, there's a risk that the EDP will do cherry picking. He will see, we have this customs administration who can do this and this and this. We'll ask the designated official to carry out these and these investigating measures. Then I have the information. I will use it for the other PFI offenses. In this case, I'm prosecuting. That could be a risk if we can apply two systems. Of course, looking at the customs law in Belgium, which is very old, and they're trying to reform already. It's a pity that they didn't use the introduction of the EPPO as a catalyst to actually reform the whole proceedings and to provide more modern rules, to provide more procedural safeguards, similar to the rest of Belgian criminal procedure. So that's a pity. But yeah, I'm looking forward to the discussion further and how the EPPO and the Customs Administration will figure it out. I've heard that they're still trying to figure it out, and they're maybe going to amend this new interaction between the EPPO and the Customs Administration. So we'll see what happens there. Thank you.
Thank you very much, Anna, for an intriguing implementation study. I'm looking at the organizer. How much time do you have for discussion? Some 10 minutes sharp? Or
No, we can prolong the session. We are not on the...
Oh, that's good. Also for the other chairs of other panels to come.
Yes.
Shall we give the microphone? Well, trying to summarize what we've heard so far, I think the three presentations illustrate three very typical problems of decentralized law enforcement in Europe. If we start with the first presentation, which dealt with implementation requirements for the national level and the supervision and control of its implementation. The second presentation dealt with the idea to expand established national procedural tools borrowed from anti-mafia legislation into new fields, which of course begs the question, is there a need for a specific approach in EU cases, and what is the specificity that requires some adjustment here perhaps? And third, Anna's presentation dealt with the issue of the integration of a supranational framework with well-grown and well-established national procedures, and of course the very important questions that we will see in many national jurisdictions these days. What about the conformity of the innovations that we see with the EU requirements? I'm sure that you have a lot of questions, so I would leave the floor to each and everyone who wants to pose a question to one of our three speakers. Do you have a microphone for the audience?
Yes.
Please.
I would like to ask a question on the very interesting Belgian system.
Please wait for the microphone.
Hello, can you hear me now better? Okay. I would like to ask a question about the Belgian system. You said that the customs can also prosecute. My question is, if there's a parallel prosecution for offenses that are linked to the same facts, isn't there the risk of nebis in idem or a double jeopardy? And how would you see that now for the EPPO investigation? Thank you.
Yes, there's indeed a problem with that, because the Belgian legislator intends that the prosecutor and the customs administration then combine their proceedings before a criminal judge and then prosecute as such. But that of course doesn't happen in practice because, or at least it happens of course, but not by all customs officials. Often the customs administration prosecutes certain facts and then afterwards nothing happens anymore by the public prosecutor. So the facts are often left like that. But of course there is a problem, and I think in EPPO it will become more important because the EPPO will have an eye for the underlying criminal activities and they will prosecute for human trafficking or criminal organizations. So I think this will result hopefully in a better cooperation so that the customs, for example, if the customs is a customs offense that does not fall within the EPPO's competence, that they might still go together and combine their proceedings. Maybe that's a possibility, but it will all depend on how the cooperation goes, of course. So we'll see. But of course, they have to report the facts to the EPPO now. They also have to report it to the public prosecutor normally, but maybe this will enhance the cooperation. I hope so, at least. I don't know if that answers your question to a certain extent. Yeah.
Further questions from the floor?
Thank you for the presentations. I'm interested in comparative criminal law and procedure, and it was a very interesting panel from that point of view. It seems that there are quite a few issues of overlapping or related competences of different authorities in every system, or at least in the examples that the panel discussed. You've got administrative authorities in Italy and judicial authorities. You've got customs authorities in Belgium, and you've got general prosecution authorities. I know that, for example, in the UK, there's a specialist and the Serious Fraud Office. I think his name's changed, but it's a specialist agency that combines prosecution and investigation powers in Ireland. There are some overlapping authorities, for example, the Director of Corporate Enforcement, and there's the General Prosecutor. And I know in Ireland there are protocols that are agreed between different offices, so they seem to have some awareness of this issue. And I was wondering, that seems in the speaker from Anna Place, yes, you mentioned about a reform of Belgian law. So is that something that could be done, that protocols could be agreed sort of in a kind of pragmatic way? Or do you think there's a more general reform needed of the relations between competences?
For me personally, a more general reform is needed. I don't see why the public prosecutor can't prosecute customs offenses although they're not specialized right now, they could become specialized. They're already specialized tax prosecutors. I don't see why they can't do the customs offenses as well, but I'm afraid the customs administration has a very strong position in Belgium, of course, because they can act so quickly and regarding the duties so good and effectively. That's why they can keep their current role, but I hope they become a more profound role, but we'll have to see. Nothing has been published or anything like that on how they will reform it. So since they're at the table to design the new law, we'll see. But yeah, at least better cooperation protocols. I think that's a possibility. Yeah. Yeah, sorry.
If it's closed.
Yeah.
Hello? Oh. Yes?
It does work. Just don't keep
Yes.
it closed.
Okay. I do. So I have a question on the Italian presentation on the anti-mafia measures. I would like to ask what legal remedies are being foreseen for these measures, the administrative measures of removal of managers, for example, and how the exercise of these legal remedies affect the effectiveness of these measures in practice. Thank you.
Okay, thank you very much for the question. It depends on the measure. So for the measure adopted by the judicial court, so the judicial authority, you can appeal to the Court of Appeal and then to the Italian Court of Cassazione, so the last court, the cassation court that we have in Italy. For the measure applied by the judicial authority, you will go in front of the administrative court, so the regional administrative court, and then to the Consigliere, the Council of State in Italy. But remedies will not stop the application of the measure. So if the interdiction is ongoing or the confiscation has been issued by the court, or if the judicial administration and judicial control will be issued by the court, if you do appeal, then the judicial administration and the public control continues. So there is no
suspension.
No.
Suspension.
No suspension.
On any case. No
No.
case.
No, if you win the appeal, that of course it can be stopped, and you can also go in front of the judge to say, okay, I'm done the compliance program. I removed my my CEO who was suspected to be close to a mafia organization. So please stop the measure, and then you can stop the measure if you can go many times in front of the judge to ask to review the judicial administration during the 2 years. Thank you very much.
Good afternoon. Thank you for the presentation. Sorry, I don't know if you can hear me or not and everything. I have also a question for Dr. Berritteri, if I can. It's a bit on the side of your presentation, because in Italy, when the mafia crimes or any problems are taken into account, there is a special branch of judges and public prosecutors that are taking care of that. And so they really are based on secrecy, silence, not giving any kind of information outside, because of course of the problems. So I was wondering if there are specific measure anyway procedures for cooperation with the EPPO for this kind of branch of judges and prosecutors, or if they are thinking how to make Italian judges that are tackling mafia be more open to share information with like the EPPO and so Europe.
Thank you for your very interesting question. There are no formal regulations concerning the cooperation between EPPO and national anti-mafia prosecutor in Italy. Of course, we have a special enforcement system also concerning mafia traditional investigation and proceeding. I didn't touch it because I focused most on the non-criminal tools. But no, there is no regulation concerning relationship between EPPO and anti-mafia prosecutor. And of course, this could be one of the problems concerning the cooperation between EPPO and anti-mafia, because EPPO, for example, can extend its competence to crimes inextricably linked to those affecting European Union financial interests, so also to organized crime offenses. Where in Italy we have also a local specialized prosecutor coordinated by the National Anti-Mafia Directorate created by the idea of Giovanni Falcone in Italy. So it's a very complex enforcement system, giving the opportunity to Apple to investigate also mafia in Italy. It's very complex, can be complex procedural conflict of competencies between EPPO and the Italian specialized prosecutor. Of course, also because during the investigation carried out in order to issue one of these non-criminal tools are very secret. So even the private cannot access all the documentation. So it's very complex because the reason why this measure been so successful in Italy is that there are less rights for mafia. This is the reality. So they are really effective because there is less, there are less procedural guarantees, procedural rights. So it's still an open issue in Italy. So we are trying to apply these cooperative compliance tools to reduce this problem, to overcome this problem.
Sorry, is it working? I'm from Public Prosecution Office, and I would like to have a question related to anti-mafia measures. And my question is, how do you know that the companies are under mafia control? How do you prove it? Do you have in national law factors stipulated by law that are applied to say that companies under law, and do have statistics available that measures are effective, that something is changed in better way? Thank you.
Source of the information.
Okay. Yes, I didn't have the time to touch every, because it's a very complex and technical regulation, the anti-mafia code, but there are different evidence when you can go to see if there is a criminal infiltration. For example, if a criminal investigation starts against the CEO, it's one of the red flags. Then there is a database of the National Anti-Mafia Directorate where there are all the information concerning police investigation, police preventive investigation, for example, on corporation, to see if they are close to people suspected of being part of mafia, because in Italy it's a particular situation where, for example, many members of mafia are of the same family. So if there are, for example, red flag concerning the surname of the owner of the corporation, then there can be preventive police investigation. And all this information are gathered in the anti-mafia database, and the prefect can enter the anti-mafia database to see if there are, for example, criminal investigation ongoing, or even first grade judgment and other investigation by the Guardia di Finanza. This is a specialized police force in the economic crime investigation in Italy. There are different routes where this information are gathered in Italy, and all are collected in this database.
Yeah, and second part of the question is whether you have some statistics or some successful cases, for example, for 1 year, half a year.
Yeah, we have some. We do not have statistics concerning these anti-mafia tools, but we have different cases of cooperative compliance tools that have been successful. For example, for small and medium enterprises, operating in the public procurement sector, sometimes it's possible to recover. When the criminal infiltration is at a high stage, it is impossible because they are all companies operating illegally. So when they have to act without judicial administration legally, they going to fail because it is possible to save this company. So then you have just the anti-mafia interdiction, anti-mafia confiscation, but with the problem of safeguarding fundamental rights, of course.
Do you have the opportunity for one final question?
Yes.
I'd like to ask you, in the case that the crime of mafia is a beef crime, under the material competence of the EPPO, who is going to investigate the Italian delegated prosecutor or the special body that you have for method? Because according to the EPPO regulation, it's a competence of EPPO. Is there a special provision in the Italy legal order, or you are going to fix it? Maybe it's
Well,
in the case that the mafia is involved in beef crimes.
yes, I understand. If there is a beef crime, the competence is EPPO. So in Italy we had, of course, the delegated European prosecutor, and he's in charge of investigating this crime, of course. When an organized crime offense is inextricably linked, of course, there can be also competence of EPPO and then the EPPO, and then there can be the problem of a conflict of competencies between EPPO and national prosecutor. But normally, if there is a beef offenses, there will be the European delegated prosecutor. But you have to consider that this type of non-criminal tools are applied outside the normal criminal proceedings. So there we will have just the Italian police forces and just the Italian anti-mafia legislator, because they are not applied in the context of a criminal investigation. So they are autonomous measures.
Thank you very much. I think we all deserve a coffee break right now. Most of us, most importantly, of course, our three speakers, who I wish to thank once more. Thank you very much indeed for three rich discussions, three rich presentations, also a very interesting discussion involving the audience. Before we head into the coffee break, perhaps one final observation and one abuse of my function here as a chair and my dominance over the microphone. We've heard a lot about idiomatic, very specific national approaches, and I sense that in particular the Italian anti-mafia approach has raised some interest in the room here. But of course, we've talked about decentralized enforcement, but nevertheless there's a very central thing. And the central thing is EU law and the need to have EU law enforced effectively. And it would probably be something that we need to address in the next panels as well, what the standards are for the effectiveness of implementation, because that is somewhat the elephant in the room here. We have so many interesting, nice ways to implement EU law, all these colorful national institutions and practices, but at the end of the day, the question is it effective? And if we talk about effectiveness, what does that mean? Is it an empirical concept? Is it a normative concept? How much variation do we allow? How much discretion? How much tolerance for national cultures, different judicial traditions? And that is something that we have to bear in mind for the rest of the conference, and also with regard to our EULEN network, because that is one of the key questions that we, I guess, are still grappling with and that we're not close to answering. So on that note, thank you very much, and now we all deserve a cup of coffee. Thank you.
Thank you very much.
I've muted it. Is that okay?
Yeah.
Yeah. Okay.
By the way,
Oui, normalement, Aurélien a déjà la liste comme là.
I don't think so, but this can be interesting because it can be a way, for example, finding a violation of the European Union law concerning national, etc. Maybe there is not the proof of a crime, but it's the proof of the suspicion of a criminal infiltration. It can go after the Italian prosecutor and say, okay, we can maybe run a judicial control.
I think that was we have a very important national competence, and where the EU competence finishes and where the national competence is started. But the coordination is power that needs to be invested.
Thank you very much for sharing. Apologies, my flight was delayed. Not cancelled, but delayed.
I work for your
Congratulations. Also ich habe gesagt, ich
Ja,
ich
bin also das passiert.
No, I always act under the authority of the law.
Das war so ein bisschen meine Hoffnung. Das ist dann sein. Das war so der Experten.
Yeah, so there was yeah, I mean, it's the same in Luxembourg. Customs yeah, it's like 200 years ago we decided to go together with Luxembourg for one rule, for one legislation. And it's one law. It's called the law. It's very interesting. Of Belgium and Luxembourg. So if we change it, Luxembourg, we have to communicate to change our laws. And I don't know, but I think there are the only two systems in Europe where the customs administration really goes to court. No, but they're also very close. Very excited. Yeah, in Belgium it's really sad. They decided it 200 years ago. Yeah, it's an issue. And the fact is, they talked to me years about it because they accepted it for a long time ago, and then
member states had implemented by 2019, I guess. But then still it took 2 years, and then still they didn't change it. We were like, okay, now we'll just place some customs officials.
Schweizer würde sagen, speziell. Speziell. Schweizer sagen.
Das wäre schwierig. They want to reform legislation, actually want to get rid of
Viel erzählen, wie
because it's so effective. They say I've had cases and there they say administrative check and all of a sudden indictment and you go to criminal court and you're like, what the fuck? You never know where the happens. You can't see the case. You can't ask for investigation measures. They just say, haha, no, I won't do that. It's insane. They always do. It's actually very dismotivating to do customs law as defense lawyer because I only do this. Now I try to do more general tax law because I'm sick of the custom because you never there's no possibility, there's no argument, nothing. Even if it's completely against EU lower standards of EU human rights. Because they don't they will put emphasis or they will set it and then they will see some information and then they go.
Anzi, io ho un carissimo amico che lavora alla Banca Europea degli investimenti, organizzazione la penna, che lavora in legale, però non fa la commerciale. Abbiamo parlato con questo programma Marco
More than 6 months for sì, ma ho detto che perché noi non so se fosse il site che non lo guardate sul fondo.
Sì, sì,
So it's always from now to They're actually good che abbiamo lanciato noi we recover all the damage. Infatti l'idea è we recover the EU budget. We can do that.
Aber ganz klar, es gibt ja niemanden.
Quello che infatti quando mi fate la domanda prima sul discorso della cooperazione dovrebbero replicare le stesse simili per not even law, sometimes. So and I è quello che comunque deve avere la Costituzione europea, non può rendere grazie all'ultimo
non ho avuto tempo di dirlo perché avevo poco tempo, ma la fra l'impresa e gli elementi che sono automatici all'individuazione. L'impresa ha 20 giorni per difendersi e c'è un minimo di contraddizione preventivo. In teoria l'onere della prova, tra virgolette, poi preventa la
Come da noi.
L'unità tecnica del prefetto, che tra l'altro è sia diciamo prosecutor che decidente, perché in realtà lui istruisce però a lavorare quando
Anche io avevo questa domanda sull'origine dell'informazione. E non facciamo è cominciato la compra
Per il riciclaggio, se non sa mai.
Dipende.
Ah, ok. Che cosa può essere? Immagino? No. Ah.
Poi abbiamo dentro il giudiziario, per i gradi economici, abbiamo un sistema con il giudice di istruzione. Durante può intervenire, può cambiare il gerente, non c'è ancora responsabilità, siamo ancora nelle indagini, può intervenire più danno. Questo durante le indagini sono cose simili, però questo esiste noi da 40 anni.
Infatti, cosa pensi? E una cosa preferisci? Ce lo puoi dire?
Io preferisco non che mi facesse impazzire la Bruxelles, perché poi prima stavo a Madrid, quindi
quindi proprio...
però diciamo che l'ho scelto
adesso stai meglio
tanti giri, no? Di persone, fai secondo, però molto omologata, no? Fai la situazione, che non è che sono tutti i fratelli strutturali,
e forse poi è un po' più nord come esatto, e questo voglio dire, quindi
sono di Bologna,
questo voglio dire, no? È quasi
sì, quindi insomma, poi vabbè, personalità, ovviamente,
perché invece Bruxelles è molto
c'è stata una bolla di
sì, può essere anche sì, però è organizzato
fare la vita che vuole, sono una libertà, invece qui non c'è ghetto, non c'è
è solo sottofono sì, però è ma io non sono devi spiegarmi, ho preso un autobus dall'aeroporto, adesso non si fa che sono tutti gratuiti. Mi è sembrata una cosa strana.
insomma, cioè queste, dai, sì, se rimangono nei confini nazionali, sì, certo, se per esempio se devi andare ad Arlon paghi solo la tariffa.
Io posso anche parlare nel momento in cui dovrei prendere. Joske, iedereen zit natuurlijk onder tijdsdruk. Als je het zelf vindt, zo voor 15 minuten zou het zo blij zijn, maar ik kan je niet verplichten.
Ik ga dat doen. Misschien dat je als je merkt van dat ik bij de 15 met mijn centje wil geven of zo, ik vind dat zwaaien. Maar ik denk dat dat met mijn presentatie goed komt. Ik heb hem gisteren geklopt op 15. Zullen wij hier gaan zitten? Ja?
I can oblige you. We've got 20 minutes.
Okay, awesome. Maybe 17.
Give it a try. Give it a try.
I think we should start.
Okay, dear colleagues and friends, welcome back to the second session on transnational enforcement. I think rightly so, transnational enforcement is in the middle of the program. Although I always have a little bit of problems, what is it about? Because transnational enforcement, it's like the long arm of course, national authorities going cross-border, applying investigative measures, but not only. I will say something about it in a second. But in fact, it's also related to the last session, to the supranational enforcement. They also go transnational. And even the EPPO, as we know, will use a lot of transnational instruments. So it might be supranational, but to a certain extent, it's also transnational. So I think it's rightly so in the mid, but it has a little bit of a not very precise definition. So I would say it's about cross-border investigations. Of course, applying safeguards to that investigation, that's really, of course, the part of it. And it's also under conditions, constitutive conditions for this cooperation. And I think that the new conditionality regime might be one of these meta conditions for the cooperation in this area. So I'm very happy that we have the three presentations and the three speakers. We will start with Joske Graat, coming from my university, but I was not involved in the selection. She is assistant professor of criminal law and criminal procedure at Utrecht University. Just defended her PhD on mutual recognition and European citizenship, so you can understand that she's very specialized in the field. And she is also a member of the Utrecht Center for Regulation and Enforcement in Europe, the RENFORCE program. Our second speaker, if I pronounce that well, Safo Katsanaki, very welcome. You're working as a prosecutor a deputy prosecutor at the Athens Court of First Instance. And you're specialized, that's quite interesting, in criminal justice, but also in computer and communication law. So this combination on the e-evidence and the cross-border gathering of e-evidence also related to the EPPO, of course, is a very interesting topic. And last but not least, Dr. Andrea Barbosa, you're assistant professor at the law school at the University of Minho, that's the north of Portugal, isn't it? And also at the Faculty of Economics in Porto. And you're active in a lot of research groups that I will not, for the reasons of time, will not mention. So I've asked the three speakers to the extent possible to limit their presentation to 15 minutes. They had 20 minutes, but in order to facilitate some time for discussion. And I bought also some time in the program, in the coffee break for the discussion. So we will have discussion. Joske, please.
There we go. So good afternoon, everybody. Thank you very much to the organizers for inviting me to be here today. What I would like to do in what is now 15 minutes is shortly discuss with you like the first preliminary steps that I've made with regard to my new research. Like John was saying, 1.5 months ago, I was involved with the European arrest warrant EU citizenship. But after a PhD, it's very nice to do something different than the topic you've been working on for 4 years. So that's where EPPO came in. My specific working paper is about the role of the National Investigating Judge in EPPO cases. But before elaborating on that, I think it's good to mention that it's actually part of a broader research project that we're currently conducting at Utrecht University. I'm doing it together with Michiel Luchman, Koen Boventeert, who are also here, and Aart de Vries, who unfortunately couldn't be here. And just in general, the research actually encompasses the entire or the role of every national judge which could be involved or who could be involved in an EPPO case. So that ranges from the investigating judge, which I'm focusing on also today, but also the trial judge. He will probably talk to you tomorrow a bit more about admissibility of evidence. So what kind of issues or challenges could a trial judge be confronted with in EPPO cases? Now that we're 1 year in, we may actually have a first view on how these national judges actually, well, let's say, work with the EPPO rules. And of course, also the judge in judicial review proceedings. Now, of course, these are three rough categories of judges we're looking into. Some judges also have more typical jobs, such as, for instance, deciding whether a case should be brought to trial in the first place. So not necessarily deciding on the merits, but deciding on transferring the case, who will also be discussed in the context of this research. So it's quite encompassing. We focus on 4 particular member states. We chose the Netherlands, Belgium, Germany, and France for the moment. And why is that? That's because these 4 countries have a particularly different outtake on the role of the different national judges in EPPO procedures. I'll also show you that in a moment with regard to the investigating judge. What kind of overarching questions are we looking into? Well, you can think of the extent that the tasks of the national judges are currently actually in conformity with the EPPO regulation and with particular features of the EPPO, such as its indivisibility, but also its definition as a single office. So what kind of changes have possibly been made with regard to the role of the national judge? What kind of challenges are they confronted with? Are the changes in conformity with the regulation? And what kind of solutions could one possible think of after analyzing these problems? Should they come from top down, from the EU, maybe bottom up from the national member states, or maybe something in between? So that's the general project that we started roughly about 1.5 months ago. Now then, where do I stand with regard to the investigating judge? So the starting point which I actually take, and which you also see a lot in the legal literature, is that the EPPO regulation is relatively silent on the role of the investigating judge in EPPO cases. The EPPO regulation doesn't prohibit it, at least not explicitly. It also doesn't install one, so to say. It also doesn't really regulate it than what it should look like. Now, of course, you do find indications, implicit ones, in the regulation, in the recitals, in the operative provisions, as to whether or not you can keep the national investigating judge in EPPO proceedings in the national member states. Recital 15 mentions that it was never the intent of the EPPO regulation or of the EPPO to actually fundamentally change the criminal investigations of the member states or the rules regarding the criminal investigations, which kind of implies that a role for the national investigating judge could be kept as long as it's not clashing with the regulation. Now, the question that I posed to myself when I had the first outlook on the systems that we are considering or that we're researching at the moment is, to what extent is that actually possible? Because the role of the national investigating judge in these different countries, to which I will come to in a minute, is very, very different. They have different tasks, they have different powers, different competences. So in that sense, it brings its own set of challenges with regard that you can actually implement the position of the national investigating judge as it was when we didn't have an EPPO yet, or at least not an operational one, and use it or kind of copy paste it into an EPPO procedure. And of course, depending on whether or not changes have been made, is the fact that no changes have been made, or the changes that have been made in the national legal systems, are they then now fully in compliance with the regulation, or do certain other questions potentially pop up? Now, as I said, we're only in the first stage of the procedure, but what I've done so far is for these three countries actually figure out, okay, how does it work in these national member states? What kind of role does the national investigating judge have there? Now, with regard to Belgium, you actually still see that there is an investigating judge in the absolute sense of the word. So there's the possibility in a preliminary procedure or preliminary investigation to act, so to say, as an investigating judge, as an examining magistrate. So within the context of a judicial inquiry, not the public prosecutor is in charge of the investigation, but the investigative judge. And I see you nodding, so that's very, when I understood it correctly, I used your article for it. It's, so they actually have an examining job, which means that the investigating judge is in charge and the public prosecutor has a bit more of a back seat. Now, in Germany, we're talking about the exact opposite of the spectrum, so the other side of the spectrum, because there the investigating judge, referred to as der Ermittlungsrichter, can only act on the request of the public prosecutor. So he or she acts when the public prosecutor asks to conduct a certain investigative measure or to provide authorization for a certain measure. So in that sense, it's questionable whether you could call the German Ermittlungsrichter actually an investigating judge, or better, a judge of liberties or a judge of the investigation. So you already see here how the role of the investigating judge can be at two opposite sides of the spectrum. Now, the Netherlands then is, well, I would say a little bit in between. It's not fully comparable to the German one, it's also not fully comparable to the Belgian one. Up until 2013, we actually had something like a judicial inquiry in the Netherlands, but it was eliminated by the Dutch legislator. And what the Dutch legislator actually wanted is a system where the examining magistrate, rechtercommissaris, only had a supervisory task. Now, the supervisory task actually covers the legality of the investigation, so a judicial authorization for certain investigative measures or a court order, but also more generally criminal investigations. So the investigating judge in the Netherlands looks at the completeness, at the progress, and at the balance of the criminal investigation, and also has powers in that regard. Now, only a very limited amount of those powers are actually, or can be exercised ex officio. So the investigating judge can use them when he or she thinks that's necessary. The rest goes on the request of the public prosecutor or on the request of sometimes the defense. Now, that means that in the Netherlands, the investigating judge has not completely lost the role of, so to say, examining magistrate. But it's really, I won't go into the details, in only a very narrow set of situations they can do that. And the legislator even said in that regard, even if the judge uses the tasks or the competences which it has, it can only do that in order to, so to say, facilitate the public prosecutor, so to complement the investigations already conducted by the public prosecutor. So there you actually see kind of an evolvement over time from an investigating judge in the Netherlands to more a judge of the investigation, so more in the direction of the Ermittlungsrichter. Now, then the next step which I took is, okay, to what extent has this changed in the national member states when the EPPO became operational? Were the rules with regard to the competences and tasks of the national investigating judge changed, or does that role just simply very neatly fit into EPPO proceedings? Now, and there you see that depending on the role which the national investigating judge has, different questions could pop up. And I've just enumerated a few here. So with regards to an investigating judge who only exercises judicial control, let's take the German Ermittlungsrichter, at face value, there doesn't seem to be that many issues because the regulation allows the public prosecutor to request other authorities to conduct certain measures or to ask for permission to conduct certain measures. It's laid down in Article 30 and 31. Could at least be interpreted in that way. So in that sense, also if you look at the legislative history leading to the Implementation Act in Germany, not that much is said about it because it is assumed that, well, the national investigating judge can just continue with the work in the context of an EPPO case. With regard to Belgium, that could be a bit more complicated and has also largely been discussed, but primarily in the legal literature and not so much by the legislator itself. So what they did in Belgium is they kept the judicial inquiry, contrary to France. France also has a judicial inquiry, but there they decided that the competences of the national investigating judge would be provided to the European delegated prosecutor in EPPO proceedings, which of course raises a whole different level of other questions. But Belgium chose a different route for different reasons. They wanted to keep the judicial inquiry. But of course, that gives rise to questions, for instance, such as what happens in case of a reallocation? So the moment that you are in an investigation in Belgium, Belgium is the handling state, and a judicial inquiry is triggered, which is mandatory in case of coercive measures which fall outside the competences of the public prosecutor, but the EPPO decides to reallocate the case to a different state. Can you take a case away from a judge? Maybe a judge who doesn't want to give up the case. That's an interesting hierarchy and independence question that could pop up there, but is not that much discussed by the Belgian legislator when they were implementing the regulation. Now for the Netherlands, a question that could come up is, okay, how about this supervisory or this more general supervisory power that we have? Because the permanent chamber, of course, can also issue instructions to the public prosecutor. So if the Dutch rechtercommissaris is then exercising certain powers in order to overview or to have an oversight over the criminal investigation, its progress, its completeness, could there be potential overlap? But that's something that the Dutch Implementation Act also doesn't mention or discuss, so to say. And then lastly, and then I also come relatively to an end, there's a bit more of an overlapping issue, one could say. That's Article 31.3 of the EPPO regulation. We probably all know that with regard to the judicial authorization, the law of the assisting state takes precedence, so to say. There's a rule of priority laid down in cross-border cooperation. But the question which pops up there, and which you also see a lot of different opinions on, is when the judge or the investigating judge in the assisting member states is requested for a judicial authorization, what kind of test can this, or assessment, what's the scope of the assessment that the judge in the assisting state can then conduct? Can he check the material requirements in its own national law? That could be an interpretation of Article 31.3. But Article 31.2 also refers to the law of the state of the handling public prosecutor as being applicable, so to say, when it comes to material competences. So either you get, so to say, a double check, or you get a check in the assisting state, but then the assisting state checks its own material requirements in its own law and may need a case file for that, which is then in the state of the handling public prosecutor and probably also in the language of the state of the handling public prosecutor. So if you consider or start from the idea of the EPPO as a single office, so to say, in which cooperation is even more efficient and better and faster than the mutual recognition instruments which we have so far, then these kind of challenges which could rise for the investigating judge with regard to the assessment, well, are they in compliance with what we're supposed to be in single office? So also with regards to the features of the EPPO, questions rise. Now, the main conclusion with what I want to add for the moment is that to a certain extent it's surprising that in the national legislation, the implementation acts I've checked so far, these kinds of questions are not discussed. Now, that may to a certain extent be because the national legislature also doesn't know for a fact how the EPPO will work out, but it's not even mentioned, and that means that it arrives on the plate of the national investigating judge at some point. So that's what I would like to conclude here for, and give the floor to the next speaker.
Thank you very much, Joske, for the in-depth analysis and very clear presentation of the issues. And indeed, we go directly to the second speaker.
Good afternoon, everybody. Okay, no.
If you go forward, then you go to your... No, you go backwards.
Okay, sorry.
It's okay. Yeah.
Okay, thank you. Thank you for the invitation. It's a great honor and a great joy to be here among you. As we have a time limitation, I don't want to abuse my time. I will go directly to my presentation, which is about the gathering of evidence by EPPO and the relevant issues that may arise, mainly the admissibility issues. Oh, sorry, again. Okay. So, when we talk about electronic evidence, I have adopted a very broad definition, meaning all evidence, not only the one born electronically, but also the one becoming electronically afterwards. The gathering of electronic evidence is more complicated than any other kind of evidence because of its nature, which is ephemeral, it is volatile, it is subject to easy movement, and of course it is hard to locate. Okay, okay. So, although all investigation measures may generate electronic evidence under the broad definition that was given, in the EPPO regulation, there are specific investigative measures that are related to evidence that should be available to European delegated prosecutor, and the most related ones are the production of stored computer data, the interception of communications, and the tracking and tracing of objects. With these, of course, measures are also subject to restrictions and limitations. These limitations can be provided under national law. And of course, interception of communication and tracking of objects, because they are highly intrusive investigative measures, they can also be limited to only a list of serious offenses that are going to be communicated to the EPPO office, and already some member states have communicated the list of offenses for which they will make available these investigative measures. The problem is with these measures, they should be available to under all national legislation so far, because most of them, like the production of stored data, is already provided under the Budapest Convention. So there would be no problem when in cross-border investigations, for example, an investigative measure does not exist. All this should exist. However, the problem could be because in some domestic legislations there are different thresholds of when you can apply and when you can adopt these productive measures. And what the EPPO regulation provides is that in that cases there should be a consultation procedure in the chamber that maybe could take some time, and when it comes to evidence, time is also present in order to keep evidence. So with the cross-border investigation involving evidence, we can have three possibilities. We can have evidence located in the territory of a member state that is part of the enhanced cooperation, in which case we have the assignment mechanism that is going to be applied. In this case, we have also the rule for one judicial authorization if a judicial authorization is required under both national jurisdictions, although under the new guidelines of the College of the EPPO, I can assume that even if only one it's provided under the rest one authorization, the guidelines are that there should also be sought due authorizations, because there should also always be a possibility to check the authorization under both national legislations. And of course, the consultation procedure if the assigned measure would not be available in a similar case. In the absence, if the evidence is located in a non-participating to the EPPO member state, then the EPPO can be designated as notified as a competent authority and to issue instruments like the European Investigation Order and the European Production Order if adopted later on. And with regard to evidence located in third states, it could also be notified as a competent authority under the international agreements. It has already been notified under the European Convention on Mutual Assistance in Criminal Matters. This is the mechanism for gathering e-evidence under the regulation. But of course, when it comes to evidence, and especially when it comes to traffic data and subscriber data, we know that this evidence is usually gathered by voluntary cooperation between the service provider and the law enforcement agencies. These cooperation schemes exist all over the European Union, and that's why these procedures have triggered the Commission's proposal to adopt the European Production and Preservation Order in order to regulate these schemes, which so far are unregulated. And apart from that, the other option is to have access to data in other jurisdictions through unilateral access, meaning from devices on the law enforcement jurisdiction without any consent directly to data stored in other jurisdictions. So far, the only legal basis and provision for this unilateral access is Article 32 of the Budapest Convention. However, this relates only to data which is publicly available, meaning which is in open source, or when the holder of the data has the authority to give consent to this data. And of course, the problem remains if we don't know where the evidence is located. If it's in the cloud, there is also the case of loss of location when Article 32 is not applicable, because Article 32 only relates to data that the location is known. And in that case, we don't even know if there is any breach of jurisdiction when accessing this data. Apart from the data evidence gathered by the EPPO, evidence will be also gathered by OLAF. OLAF has under the new regulations, has extensive powers to conduct investigation on privately owned devices also when they're used for work purposes, and also there are guidelines on how OLAF will make these investigations. And within the scheme of cooperation with the EPPO, the OLAF will provide support. They already have a working arrangement with EPPO, and which includes these forensic activities and this cooperation and this assistance that OLAF will provide to the EPPO regarding gathering of evidence and conducting of investigations. However, there is also the problem of the admissibility of the evidence that's going to be gathered, because we have no harmonizations of the rules of conducting investigations. There is also an assimilation clause under Article 37, and only Article 32 aiding us with the formalities that have to be abided with when indicated by the European delegated prosecution. Of course, the admissibility of evidence is also the same when it comes to evidence, because we have no uniform rules. Although we have tools to ask for evidence, we have no uniform rules on how to gather this evidence. We have no rules on casual findings, meaning of evidence. When you're looking at the evidence, you may find evidence of other crime related, and you don't know how to handle this evidence. And of course, there are no rules at all on evidence collected from law enforcement agencies from private sector, or evidence gathered by unilateral transporter actions. There are rules in some jurisdictions have already rules in their criminal procedure codes on how and when they will access from their jurisdiction to other jurisdictions the evidence, but they're not union-wide uniform laws. And this would mean that we would not know how to handle this. And of course, we have the admissibility evidence gathered by OLAF, because it is gathered in an administrative proceedings. Sometimes, in some jurisdictions, OLAF has the right to use highly intrusive measures, although it is only conducting in administrative investigation, while in other member states, during administrative investigations, it would not have the right and the authority to use such intrusive investigative measures. And of course, the only clause helping us with admissibility is the assimilation clause of its reports. But the assimilation means that in the national jurisdiction where it's going to be used, this evidence has already administrative proceedings and administration that can conclude the same results and has the same power, so it will not always be useful. And another interesting issue of evidence, once it is admitted, it comes the question to how it is assessed, meaning which is its probable value. When it comes to evidence, means that if it is safeguarded and made sure that it is authentic and the integrity has been safeguarded, meaning that we have to preserve the chain of custody from the moment the evidence is gathered. There has to be everything documented until it is presented to court to make sure that what was initially seized, the evidence is the one that comes before the court. Again, in the EPPO regulation, there is no unification of the assessment. It's left to international law. However, there are a lot of international guidelines, there are best practices, there are handbooks and guides that are used within the European Union, and there are certain standards for the experts to use when dealing with the evidence. And at least this is a framework that helps most courts, once the evidence is admitted, to accept it also as having a probative value. And when the court doesn't understand, in almost all jurisdictions within the European Union, the forensic experts will come to analyze and give their opinions on the evaluation of the evidence. As a conclusion, I would like only to point out that harmonization of rules concerning the gathering of evidence is needed. The partial harmonization is made through the Budapest Convention. All of the states of the EPPO participant people have adopted the Budapest Convention and has also enacted the provisions of gathering evidence. So there is a partial harmonization. It will be a further one if the second protocol is adopted that has more options of asking evidence from domain service providers and from other service providers. Specific legislation on special investigative measures which are highly intrusive would also be necessary, accompanied by procedural safeguards. Also, it has been proposed a legal instrument for the admissibility of evidence on the mutual recognition, even that the EPPO could use the European investigation order, which has simplified so far the access to evidence and to evidence as well. And as regards OLAF, which is highly also reliant on national law, maybe if it had autonomous investigative power also coupled with safeguards provided under the EPPO regulation, also the e-evidence gathered by it would be more easily admitted and accepted in court. That's all I had to say until now, and thank you very much for your attention.
Thank you very much, Safo, for the analysis and presentation. I think you understood that although we are in a common legal area, the area of freedom, security, and justice, that the collection of evidence, and specifically here e-evidence, and then also the admission and the assessment of the e-evidence in national courts remains a very, very difficult issue due to the lack of harmonization and would say streamlining of the instruments. We certainly will come back to that in the discussion. Then the new conditionality regime. That's really a very innovative topic, but also very actual.
Well, good afternoon, everyone. I do not have any PowerPoint presentation to share with you. Considering the theoretical approach that I decided to present, I would say that it's not necessary, at least I hope so, but let's see. Well, first of all, I would like to express how glad I am to be here at the University of Luxembourg, and I would like to thank the conference organization. Well, the European Union has faced several crises in the last 10 years. The Euro crisis, the refugee crisis, Brexit, and the pandemic crisis, and it's being driven by a natural survival instinct. And these crises, not being existential crises of the EU, are challenges that test its limits. And today we are experiencing one of the crises that best tests the Union's values, and it's the crisis of the rule of law, especially in its dimension democracy. Democracies are fragile, and cases of democratic backsliding exist. And democracies are not always able to protect themselves internally, demanding the adoption of external measures. And it was precisely in this context of precisely in this context of the impossibility to protect the democracy internally that the conditionality regulation emerged, the regulation 2020-2092. Well, in my perspective, the emergence of this crisis can be better understood as an expression of the own nature of the Union. As is well known, it is possible to look at the European Union in the light of the Federal Constitution, assuming the Union not as a state, not as an international organization, but as a structure really close to a federation of states. In other words, this crisis of the rule of law seems to be easily perceptible if we start from the recognition that a federative structure is at stake. Federal systems are by their nature unstable, living in an existential imbalance between the interests of the states and the interests of the federation. This imbalance will continue until it is decided where in fact the power of normative creation is. And as can be seen, the European Union is facing this problem and has managed to solve it through the doctrinal constructions point out as the systemic harmony between the constitutional order of the Union and the constitutional orders of the states in the light of principles of constitutional tolerance. Constitutional pluralism is typical of federal states or federal constitutional orders in a systemic harmony that presupposes substantial axiological homogeneity. Knowing that among the member states such homogeneity does not rely on religion, language, or ethnicity, then homogeneity could be based on agreement on essential dimensions, which in the case of the EU rely in the rule of law as a meta principle. And the rule of law calls for public action not only in accordance with the law, but especially in accordance with good law. This action, guided and limited by legal norms, is extended to all dimensions of the state's action, and here I'm going to focus on the fiscal sphere, on the tax dimension. Well, as the tax dimension is concerned, the concept of the EU as a federation ends up, at least in my perspective, even being reinforced through the adoption of the conditionality regulation. Indeed, a federation must be guaranteed the opportunity to reserve to itself the competence to react against attempts to defeat purposes of fiscal solidarity, especially when considering the problems of opportunism that the sharing of tax revenues can generate. If until now the power of the EU to intervene in this area could be questioned, the conditionality regulation appears exactly as a way for the Union to reserve to itself the control over the terms in which the resources are used. So the conditionality regulation provides a clear link between respect for the rule of law and the efficient implementation of the Union's budget and available resources. Part of these resources come from the collection of taxes. Well, the fundamental values of the European project, such as the balance of accounts, budgetary stability, the sustainability of the Union, depend on the existence of financial resources. The implementation and maintenance of the European project has costs, and the unjustified decrease in revenue due to artificial behavior of taxpayers can mean the irregular functioning of the Union's institutions and can make the attribution of social benefit difficult. It is in this sense that under the terms of the conditionality regulation, good financial management is associated with investigation and prosecution of cases of tax fraud. So, here, the implementation of the rule of law is directly dependent on the way in which member states guarantee the construction of a legal tax framework capable of ensuring that the fiscally abusive behavior of the taxpayers finds in the legal system a response that allows it to implode with its non-legitimate pretensions in a triple line of action: investigation, prevention, and sanction of behavior. Well, related with this dimension, I'd like to highlight here three main issues that I can identify in the European law with this regard. First of all, the regulation, the conditionality regulation, is not clear about the abusive behavior that is covered by it. There is an evident terminological difference between what is stated in the recital 8 of the regulation and the provisions of Article 4, paragraph 2, which difference may not be located merely on a theoretical discursive level. This is because, while in the aforementioned recital 8, the reference is made to both cases of tax fraud and tax avoidance, in the Article 4, paragraph 2, the reference is made only to the most serious cases of tax fraud. So the question here is whether the European legislator intends to refer to only those cases in which the set of voluntary acts of taxpayers that are practiced in a completely illegal framework that aim to achieve a result of removal, exemption, or tax deferral, so cases of tax fraud, or whether it is also intended to cover the voluntary acts of taxpayers that, although practiced in a generic legal framework, in a generic framework of lawfulness, are qualified by the tax rules as anomalous or abusive. In this situation, then, cases of tax avoidance. Considering the consequences that could arise from the application of a regulation, these issues should not, in my perspective, remain unresolved, but the Commission's guidelines on the application of the conditionality regime do not refer to it. Since the purpose is good financial management and the protection of the Union resources, and knowing that in both cases, tax avoidance and tax fraud, the purposes of tax revenue could be frustrated, I think it's possible to conclude that it is more in line with the reasoning of the regulation to consider that a state violates the principles of rule of law when it does not guarantee in an effective, proportionate, and dissuasive way the investigation, prevention, and sanction against both cases of tax avoidance and tax fraud. Obviously, that as far as the specific definition of fraudulent behavior in terms of VAT, the Directive 2017-1371 will be decisive to better define the cases in which such behavior does not receive an adequate response from the national legal system. The second problem, the level of protection that the European Union law guarantees in combating abusive behavior is really limited in its scope. Well, in an attempt to define the scope of the provisions of Article 4 of the conditionality regulation, the activation of the mechanism provided for in the regulation could be justified, especially when the aforementioned abusive behavior may result in the non-collection of taxes that directly affects the resources needed for the Union to achieve its objectives and implement its policies, such as exactly VAT and customs duties, both European Union own resources. Since it is at stake here, taxes that already know a high level of harmonization, the differences between the legal systems in terms of reaction against abusive behavior, especially through the coercive tax collection and the criminalization of behaviors, create a lack of mutual trust between administrations and undermine a level playing field for economic operators in the EU. And a reference here only to VAT and customs duties could be also justified in the light of the Article 22 of the Council Regulation 2017-1939 establishing the European Public Prosecutor's Office. This article states that in any case, the European Prosecutor Office shall not be competent for criminal offences in respect of national direct taxes. So which means that in terms of income taxation, EPPO will not have competence to act. Well, it's possible here to associate the solution that is set in the regulation and connecting it with the European Union own resources. I think it's easy to understand, but it's difficult to accept. And why? Because fighting profit-driven crime is at the core of the mission of the European Public Prosecutor's Office, and EU member states lost an estimated 134 billion euros in VAT revenues in 2019, according to the 2021 report on the VAT gap released by the European Commission. VAT fraud often goes hand in hand with direct tax offences and is ultimately committed either by presenting false, incorrect or incomplete statements or documents or by non-disclosing VAT-related information. Frequently, this conduct simultaneously involves both VAT and direct taxes. In case of simulated transactions in a carousel fraud, an economic operator might not only illegally claim VAT refund, but also deduct from the taxable basis the expenses related to the simulated purchase. Both the VAT and the direct tax offences would be committed via the one and the same false or incorrect tax statement. In addition, and in context of a foreign company that avoids creating a permanent establishment in an European Union member state with the purpose of avoiding taxes, the charges might include both direct taxation and VAT as a consequence of non-disclosing information related to both taxes. So it's a possibility here to apply the inextricably interlinked concept, but considering that there is a lack of definition here, the legislator doesn't provide a definition of inextricably interlinked, and this lack of definition, I would say it's not compatible with the legality requirements for the tax dimensions. The last issue that I would like to present here is related with how questionable is the absence of an analysis mechanism of a judicial rather than a political nature, which would make it possible to assess whether such violations of the rule of law actually exist. The assessment of compliance with the rule of law, particularly in spheres such as taxation, which are particularly demanding in terms of legality, must be assessed judicially, not politically. Should the Council have the possibility, even before deciding on the application of the measure, to raise the question of whether the internal measure complies with the requirements of the regulation before the Court of Justice of the EU? The fact that the regulation does not provide for judicial control, neither in tax matters nor in others, seems to contradict the foundation on which it was established. Are the requirements of legality and representativeness in tax matters compatible with an expertocratic base? Is the possibility of the intervention by the Court of Justice merely a posteriori, merely after, compatible with such requirements? So in conclusion, I would say that the European Union is committed to ensuring that its own resources and budget are protected. However, its performance remains very limited, and it will continue to be so until the need to implement a law of execution in tax matters is accepted. In this regard, I have a suggestion in terms of interpretation here, because I believe that it is legally misleading to continue to emphasize the need to protect the sovereignty of states in order to avoid further advances towards an effective fiscal federation and in order to avoid changing the unanimity rule in tax matters. It seems questionable for me that one can speak of a loss of fiscal sovereignty, and why? Because even in the cases where legal discipline is created by the European institutions, sovereignty will remain in the sense that the respective application in the internal order takes place only because the Constitution, as an internal fundamental law, so admits. So with sovereignty, states allow European Union law to be applied internally. So this reasoning, this way of interpretation enhances the acceptance, at least abstractly, of an effective fiscal federation in the context of which the respective member states implement the law centrally created, reflecting what practice already demonstrates, given the way in which union law, when issued, exhausts the regulation of tax matters, at least in the sphere of indirect taxation. Anyway, I should recognize here that this issue of fiscal federalism has been an academic debate without particularly relevant connection with reality. Even though fiscal federalism is not equal to political federalism, which means that the EU is not obliged to transform itself, at least not in a formal way, in a federation, it still requires some kind of political support. And this one, well, I would say it is still to come. Thank you for your attention.
Thank you very much, Andrea, for the rich contribution combining, I would say, European constitutional approaches and here fiscal federalism related to the new conditionality regime and our specific area of the protection of the union's budget. I think we have here a very good example of what Frank was hinting at about effective enforcement. You see good financial management of the union budget, including, of course, the law enforcement side, related to the quality of the rule of law. It's quite unthinkable if the prosecutor's offices at a domestic level are not independent or politically influenced, and the same for the judiciary. That's, of course, become very difficult to have a good quality of enforcement. So, and there, of course, the union is coming in and monitoring and setting conditions and also limiting financing. So, and that's, of course, I think, very interesting. Thank you so much. I open the debate. We have time. We certainly have 10 minutes for questioning. So I apply the same procedure as Frank did. Just collecting one by one and then giving it to the speakers. You have a micro.
Good afternoon.
Some distance. Don't eat the micro.
So sorry. I will try again. So, good afternoon again. My question would be to Dr. Barbosa, if I can. And it's more about your opinion, because the rule of law crisis, I will explain maybe, has been on the table for quite some time now. And even though in the EU we have tried to enhance the ad hoc procedure, the Council have never like expressed their vote in favor of going against this country like Poland and etc. So I was wondering if you think that now with this regulation they will do it, especially considering now that the war on the east side is putting the same country like on another side, because they are now opening their borders and doing a lot of efforts. So politics is always in the middle. Do you think that we really do it in the end? That we really use this new tool?
I think it's working, right?
Let's try it. You never know here.
Can you hear me? Yeah. Well, I'm not sure if I got exactly your question, but probably you're wondering if it's possible or if this mechanism of the conditionality regime could be applicable. Is that it?
Yeah, but it's related to the position of Poland and Ukraine. Of course, it's the political game that.
I'm so sorry. Obviously, that's I would say the most difficult answer here, considering the position that we all know that Poland and Hungary they decided to assume here. The terms of the rule of law requires, I would say, an agreement within the values of the European Union. And considering their position, I would say that it's questionable if these countries are or not complying with these requirements of rule of law. Probably not, and that's why they are now facing the consequences. Considering exactly the war here.
But
sorry.
you also insisted on a independent judicial assessment of the.
And they do not have that
No.
judicial.
No.
But my intervention regarding with the judicial assessment, it would be before the application of the measures to guarantee the European Union Court intervention. It was not exactly in that perspective, but I would say that we cannot. Oblige a member state to leave the European Union, right? Because it's more or less obvious that Hungary and Poland, they are not complying with the dimensions of rule of law here, and especially considering on how they are managing the war crisis here. Obviously, we can all leave the European Union and create another thing apart from it, but well, I don't know if it was just an opinion, right? I don't know if it's enough for you or not in terms of subjective perception, but thank you very much for your question.
Well, we had 3 speakers, 3 topics, don't be afraid.
A question for Dr. Barbosa. I'd like to ask you what you believe, your personal opinion, of course, about the possibility to extend the competence of the European Union to intervene in criminal matters besides the big crimes. It's an ongoing discussion about terrorism or the environmental crimes. What do you think about it?
Well, I'm not comfortable to talk about European competences in crimes dimension that they are not related with the tax dimension. Well, I think it's preferable to not use the microphone. Probably. Well,
Go ahead.
well, I would say that all the questions related with the lack of European intervention could rely on the idea of sovereignty losses. The problem relies on that, and I would say I'd like to exactly on how I tried to finish my presentation here, that if that's a problem, if the problem is the necessity to guarantee internally the competence to criminalize behaviors, I would say that's not the legal reason. It's not available. It's not needed anymore, considering on how the Constitution could allow the implementation of the European Union law. So, in terms of criminalization of the behaviors, I would say, well, the reason would rely on the sovereignty, and as you can see, I'm not favorable to that interpretation. For me, the problem is not sovereignty.
Shall I do this? Okay, I'm just kidding. My name is Stanislav. Are you sure? I tried to speak up. Maybe we need to turn this one on and the other off.
Mute, I try. Yeah,
Yeah.
give it a try.
Okay, let's try.
Viva voce, viva voce.
My name is Stanislav Tosh. I am associate professor of compliance and law enforcement here in Luxembourg, and I have a question to Safo Katsanaki on electronic evidence. Thank you for this presentation. It was a lot of very interesting thoughts and food for thought. And I have this question.
from the perspective of the EPPO, how much can we speak of, so to say, procedural forum shopping by the EPPO, who can try to get electronic evidence here and there in different countries by using different rules that we have? I mean, some countries are much more focused on territoriality. Some countries like Belgium have this approach that you don't even need to be present there. So how can the EPPO, because of course the national prosecutor will have its boundaries, but the EPPO is more European, so how much there is space for forum shopping? And I'm wondering if you reflected how much the second protocol that you mentioned in the last slide and the e-evidence that is coming but stuck somewhere in the pipeline, as we know, can help in that.
Well, first, okay, you can hear me, right?
Yeah.
Okay.
Maybe for the streaming, we need to open it.
I think you can now.
Yeah, the streaming with the.
It's on. It's on. It's already.
It's green. It's green.
First of all, with regard to traffic and subscriber data, which is I haven't mentioned it. It is on my publication. It's not. It was not on the slides. The major amount of data required is traffic and subscriber data. Law enforcement agencies do not usually require content data. They would need in some investigations, but the vast majority of e-evidence required is subscriber and traffic data, and mostly required not within the European Union, also outside the European Union from service provider in the United States. So far, I think within the European Union, this data is required through the voluntary schemes I mentioned. Not even the European investigation order is used. So I guess that these voluntary schemes will still go on until the European production and preservation order, the regulation is adopted. Until it is adopted, they will still, the law enforcement agencies throughout the European Union, require this data through these voluntary schemes. So as long as these voluntary schemes made by service providers are made with all the law enforcement agencies in the European Union, at least with regard to this kind of evidence, I think there is no kind of force shopping, because they give them to everybody. They make no discretion, the service provider. They give to all the law enforcement agencies in the European Union. The problem would be maybe because some member states have enacted legislation for transborder access, unilateral transborder access, while others they don't have. But what happens in practice, and I've seen it also, and they've already written, is that sometimes some countries are aware of it and they have legislation, they have enacted that I can access data outside my jurisdiction from a device in my jurisdiction. It is provided under law. However, in practice, in many countries who don't have this legislation, they also do it. Sometimes they're not aware they're doing it because they don't even know where the data is located. If it's in the cloud, it could be anywhere. So even there is no specific provision, then it is, if no specific provision, they even do it. So even with transborder access, I think there will be no forum shopping. What could be done is, in the case of Olaf, I did not go into detail, but Olaf could, in some countries, I'm not aware of which jurisdictions are these, but there are jurisdictions where highly intrusive measures can be used in administrative proceedings. In other jurisdictions, these measures could only be used in criminal proceedings. So, but I don't see there is any forum shopping in that, because Olaf will just go to do the investigation where it has to do it. If it's lucky enough to be in a jurisdiction where it can use this highly intrusive measure, then of course it will use them. But then the problem of admissibility will come, because it will, if it has to be used in maybe another jurisdiction, if it's a transnational character of the investigation, then maybe it will have admissibility issues. If it's in the same jurisdiction, then again, there will be no such issues. What I'm trying to say as a conclusion, and because this gathering of the evidence, it's a gray area, it's not fully regulated, not of course in European Union legislation regulated.
is that because we have uniform and best practices, and practice has paved the way on how to ask e-evidence, it's almost a uniform practice without being provided by law. So I don't see many cases with regard to evidence of forum shopping. I don't know if I answered your question, or if you come along with a case of forum shopping that I don't come along at this moment.
Thank you.
Just wanted to add to that, maybe they will do foreign shopping on the admissibility rules of evidence?
Yeah. In the admissibility, maybe. If there is a basis to bring a case, if all the other preconditions are met to bring a case in a specific jurisdiction, yes, if it's easier to admit. But when it comes to evidence, because we have no law, I think all jurisdictions will accept evidence required and given voluntarily by service providers. I don't know if from your jurisdiction you have a different, but I think that in most jurisdictions, because these schemes exist, they will all accept it. I'm not aware of all the jurisdictions. That's what I think. And because they're in the European Investigation Order, in the European Production Order, there is no provision for the admissibility of evidence. However, I think the judges, the biggest issue would be the assessment of evidence, which I said before, because the judge would not understand, is that the evidence that he really found there, or maybe they tampered with it, maybe it's changed. This could be a more crucial issue, I think, for judges or prosecutors, because if the practice is going on for years now, with no legislation, especially with traffic and subscriber data, I don't think that courts have problems to admit it. The difficult issue would be then, okay, but is it really the data that he seized? Because it's data, it can be tampered with, it can be, how do you preserve it until court? Maybe during preservation something happened. This would be the next difficult issue. There are no specific legislations again, because it would be admitted, but then is that what it was? That would do with the assessment. But again, I said there are some best practices for law enforcement agents, what we do, how we collect, how we keep, how we preserve, how we make backup copies. There are these rules to make sure that when presented before court and admitted, then they say, okay, this is the data he collected, and this data indeed proves that. And of course, we have the experts, because a judge and the prosecutor cannot understand all this procedure and how, and if the integrity is safeguarded. We may have all the chain of custody, but we don't understand it. Then experts come in, I think in all jurisdictions of the European Union, and they help. And yes, I think that the issue of assessment is also faced.
Seeing the time, may I conclude with an observation on the presentation of Joske? I think the role of the national investigating magistrate or judge, it's not only about the label, who is doing the investigation. I think there's a whole discussion behind in the member states having examining magistrates about the, I would say, the division of labor between the prosecution office and the magistrates doing investigations. And this, of course, has to do also with the independence of the judiciary vis-à-vis to some prosecutorial officers that are not so independent. So that, I think that's an important debate. And of course, the EDP is independent on paper. And that will come back, of course, in the discussion. So I think that's one dimension of this interesting topic. Another one that I think was present in your presentation, but a little bit hidden, I think you could activate it a little bit more, is of course the role of the judiciary. So magistrates, classic judiciary in the pre-trial investigation, or so in the pre-trial setting. You mentioned, like in the Dutch example, where they are monitoring the investigation and also checking the legality. I think that's an important function that has different, I would say, different architecture in the systems. In some countries, these are pre-trial courts even. So, and in some countries, it's the investigating magistrate. So that's another dimension of the figure. So monitoring and checking legality and also speediness sometimes of the investigations. So I think that there are different dimensions hidden under the concept of national investigating judge. Last remark, but I already mentioned you that I think there is, because you have selected for the moment being, you said, a set of countries. I think that is a very interesting case that you really should tackle, and that's Spain. Because in Spain, all investigations are done by investigating magistrates.
Aren't you in the process of adapting that law?
Yes, like many countries, there are discussions and there's a reform, etc., etc. There are exceptions to that, of course, in terrorism, etc. But there you have really a clear-cut case of where the investigating magistrates have dominos, are dominating the whole system. And then comes an alien comes in, an EPPO with an EDP, which is a completely different design. So I think that's a very interesting comparison.
In that case, Portugal as well.
And Portugal as well. The whole Iberic
May I
dimension.
add something to that?
Please, please.
What I was thinking that it was very interesting, your presentation, of course. I think it's also important to take into account how the judiciary really works in the countries that you will deal with. Not only what it's stated in the law, but what is really happening. What the percentage of the cases actually the investigating judge or the judge supervises. And it's also very important for us in Greece because we have a very strong investigative judge. Similar to the former French one.
Yes, the old French classic.
Yes, the old French.
The Système Napoléon.
Yes, exactly.
Thank you so much. Last question. I see you have been insisting. I don't want to punish you. Yes, please.
I have a question for Professor Graf.
Perfect.
Concerning the role of national judges, because you questioned whether this role is compatible with the EPPO regulation. And we are now discussing in Italy how to deal with dismissal of cases, because dismissal of cases should be requested by the public prosecutor to the judge for the preliminary investigations. And as far as I know, so far we had one dismissal at EPPO level, and the delegated prosecutor asked the judge whether the case should be dismissed or not. So my question is, don't you think it's fine to have this role for national judges? After all, EPPO regulation is about investigation and action. Jurisdiction is national, and this is made clear everywhere in the regulation. So don't you think that this role to national judges should be the same as at national level, even in the investigation stages?
Okay, I'm going to not use the microphone. I'm not even going to try. So if you can't hear me, then please let me know. Thank you for that question. Actually, that's a function of a judge. I would say it could be an investigating judge. In some countries, it's a pretrial judge or even the judge of the trial who makes that decision whether the case will, for its merits, actually be admitted to court. So just as a disclaimer, it's not necessarily in all systems an investigating judge. But that particular function of a judge has also not in many of the member states been discussed. But what I've seen so far is, of course, if the public prosecutor is being instructed, so to say, to take the case, then it is then within the national legal system, so to say, which could also mean that indeed a national court could then decide either to dismiss it or to bring it further to trial. So at this point, I don't know the Italian system for sure, but I think the Belgium has something similar. That I see it on the button. It's not necessarily a clash with the regulation to allocate that particular task to whatever it is, a trial judge or an investigating judge. That would be my answer for now. Yeah.
My very sincere thanks to the speakers and to the public and to the interventions and for the intervention. Thank you so much, and you deserve another break.
Yeah, I think that the prosecutor will investigate, however he will adjust so the judge investigating just the just before child detention for ordering some seizure or measures yeah, something like that. But I think okay. I don't want to I think I've heard someone discussing with somebody
accessible prices.
For the Belgians, is that they kept
There are some I know, but I don't
and
remember the names.
we can price now.
From the emails.
Yes.
Yes.
You're
That'd be
looking
great.
for a restaurant.
Yes.
What is your budget?
30, 40 euros per person.
Okay, that's not bad. Where do you stay?
I stay 20 minutes away from here. So I think.
In the center?
Yes, after lunch.
Okay. Let me see. You could try Panam. It's spelled Paname. It's like a bar restaurant.
Like Panama?
Yes, let me write it down for you. What else? Well, usually it's in restaurants here because they're very expensive. I know some restaurants here.
But this area is the most expensive.
Yeah, it's a business area. I will give you my email, and if I think of any others, I will tell you. You have it. Okay. So write me, and I will come back to you.
Okay, thank you very much.
You're welcome.
Thank you.
Let me put them upwards.
It stays open. No, don't.
No?
Ja, ik heb ook een Wel, ja, snel, ja, kom wel goed snel. Ik had de hele dag in de kast.
methods were used for another application around
So difficult. I do not have any right position. I would say.
I thought about so artists like position maybe like some political managers.
I think the data diciamo di regulation or updating the organizing regulation because people so sorry. Not so serious in their it's consequences and something like that. I can find the
You go from those two doors, you will see them to your right.
Just assuming that premise that the revelation was thinking on adaptive viewpoint.
La qualità dell'istituzione va
So I hope that you can follow the research now for PhD for una ragazza che Stelle adesso è nordico con Stelle che alla fine ha Stelle sì, ma anche non lo so, è più caotico così insomma ci cadenza e io
la gara, la stazione centrale, così con qualche sperma,
vabbè certo infatti immagino io sono al centro no io sono proprio al centro quindi ancora questa dice ancora ci sono andare qua
dall'aeroporto ok.
Sì, no, infatti.
Guarda, per esempio, che l'università per esempio è sempre aperta, noi possiamo andare.
Quindi questa è l'unica sede.
Questa è la sede del faculty of law. Economics? No, economics e campus no, economics and finance.
Però se quello è possibile, c'è qualcosa la strada c'è il facilità. Quindi una cosa ancora
a parte
dedicata, ma quindi i corsi ma sono gli stessi corsi che in francese sono diversi, non
No, il professore sceglie questa Grecia che faceva il corso di inglese in francese, switchava da una lingua all'altra, era
ma quindi nasceva inglese e francese.
penale parlando, francese, belga, francese, tedesco, La lingua, il dialetto tra il francese e il tedesco.
A me fa più, vero? Invece qui sono più tedeschi. Credo che oggi non faccio l'inglese, l'idea infatti ho fatto il mio di brevetto, di
la parte però avere una bella base sul terra sicuramente un sacco poter capire il meccanismo di interconnessione, perché molti si occupano anche sì, magari è così
sì, io anche, insomma,
dimenticato che c'era
delegated customs official. They placed it under the European delegation president. He's separate from the customs authorities, and he's also separate from EPPO. He seems like he's. They relate this, but now because of the legislation under the authority so it's a kind of a half law. Also, the European prosecutor for Belgium already said, like, yeah, the legislation is not very compliant with the regulation. But we'll apply it in a way that it is compliant. Then I have to say, after they have to put aside the national. Of course, the regulation is directly applicable, so we can put aside the law. But yeah, the customs administration will say, hey, it's in Belgian law that we have to. And then if you look at the EU, I have to discuss this. No, faccio fatica a fare. Because now they're still investigating.
Però
we can have customs administration under there's no cases.
però non ci sono
I don't know what the judges will do. Both administrations will be there.
quello ce la fai.
Yeah.
È rimasta nel 2017. Te lo dico perché non capita più una cosa così. Poi è chiaro, è una progettazione aperta, però adesso ci sono la virgola dall'interno di maschi, la lava di maschi, le donne c'è una priorità. Interessante, non ci pensavo assolutamente, però. I'm ready. I am ready.
Hi.
Hello.
We finally meet in person.
Yes, Sophia.
Yes, yes.
How are you?
Good, you?
You came out
all the way from The Hague?
Yes, yes. It was really happy to finally. Because last year we had it online.
Yes.
So I said, okay, even if I don't present, at least I can.
One question: are they sitting there with me, or
Yes.
and they are standing only for the presentation?
Yes.
Okay, and I can introduce them from there.
Yes.
Okay, so I don't need to jump here and there.
No. I also have their bios if you need.
I printed everything.
Okay. So I ask everyone to come.
Yeah.
Check
I leave it to you.
Yes.
Κοιτάξτε, μπορεί κανένας να κάνει ό,τι θέλει, έτσι, μόνος του.
Θα βάλω, ευτυχώς ανοίξαμε.
Πιο, ας πούμε, φορμά.
Good afternoon. Nice to meet you. Please take a seat. I was just looking.
Και εσείς, Ελληνίδα, η Βικτόρια. Χαίρομαι πολύ, Παναγία.
Okay. It's best.
Do we have a mic?
Yes.
Ladies and gentlemen, good afternoon and welcome to the third session of this very rich program. In this session, we will analyze supranational enforcement and we will have 3 presentations. You will excuse for my non-perfect pronunciation of your Greek names, but I welcome the speakers to my table and we will start immediately with Victoria Koutsoupias. Victoria is a member of the legal council of the Greek state. She has a PhD in law from the Democratic University of Nasa. Okay. So sorry for that. And the topic of Victoria's presentation is the European Commission's proposal reform package on anti-money laundering and anti-terrorism financing, a step forward to combat the existing inadequacies. I leave immediately the floor to you for your presentation. I would ask the speakers to stick to the 20 minutes because apparently we are running a bit beyond schedule, so time is relevant and I have been asked to check carefully on the time management. Victoria, please, the floor is yours.
Thank you. I would first of all like to thank the organizing committee for this most interesting and useful conference and for giving me the opportunity to be part of it. This presentation will focus on the new authority for anti-money laundering and countering the financing of terrorism. Its structure, its tasks and powers of the new authority will be discussed during this presentation. The financial supervisors in the EU, along with money laundering, can be a visible cat and mouse game that has been at play for a rather considerable time. The problem is that money laundering brings some rich oligarchs immediately to mind, but in reality, in the majority of the cases, there is an apparent involvement of the most perfectly venerable credit institutions. Nevertheless, their supervision appears to be both weak and ineffective. Bearing the above-mentioned facts in mind, in June 2021, the European Commission issued the proposal for regulation of the European Parliament and of the Council, establishing the authority for anti-money laundering and countering the financing of terrorism that will be established in 2023, with aim to start most of its activities in 2024. The establishment of the new authority appeared mandatory in the aftermath of a number of cases of alleged money laundering with cross-border elements and an inconsistent approach of the competent authorities that took place in July 2019 at credit institutions. Although the existing legal AML framework has been improved through many adjustments, it is still obvious that the current framework is being applied with divergence. As a result, there are some structural problems to prevent the abuse of financial system in order to serve illegitimate purposes. It has to be stressed that any disintegration and inadequacies within the implementation of the legal framework in an integrated market creates significant risks to the coherence and the soundness of the Union's financial system. Therefore, it is important to ensure prompt and consistent measures for an effective implementation of the AML legislation, especially by designated authorities such as supervisors and financial intelligence units. In the light of the above considerations, the Commission proposed the formation of the new authority that aims to counteract the existing inadequacies and address the shortcomings of the supervisory authorities by supervising directly the high-risk obliged entities, while indirectly oversees the remaining entities. The new authority shall be a body with legal personality in the form of a decentralized agency. The European Union agencyfication mechanism is considered successful. Accordingly, their functional and normative significance has become central in the institutional discourse. The new authority shall be the centerpiece of an integrated AML-CFT supervisory system, along with the national authorities. This newly created decentralized agency of the Union shall be funded partly from the EU budget and partly from fees levied from obliged entities. Now, the authority's structure and its governing bodies are as follows. First of all, the General Board that is comprised of the authority chair and the heads of supervisory authorities of obliged entities in each member state, both with the right to vote, including one representative of the Commission without the right to do so. The General Board, under its supervisory composition, is a decision-making body, and it has also providing its advice and opinion on draft decisions of the Executive Board. It also oversees the joint analysis with one or several FIUs between Member States. In addition, the Board ratifies the draft regulatory and technical implementation standards mentioned below, as well as opinions, recommendations, guidelines and decisions in order to achieve harmonization with the AML legislation. The second body, the Executive Board, consists of the Chair of the Authority, 5 full-time members and a representative of the Commission when the Executive Board executes all of its tasks, except decision-making regarding the internal structure of the authority. The authority is represented by the President, who is responsible for preparing the projects of the General Board, and the Executive Board, who are in charge of preparing the daily agenda, assembling, chairing all the meetings, and submitting the issues for decision-making. The Executive Board bears the responsibility for the overall programming and the execution of all the duties of the authority, as well as the issuance of all its decisions. Furthermore, the duties of the Executive Board include the approval of the annual program and the budget of the authority. At the same time, this is a decision-making body regarding the establishment of the internal structures of the authority and any relevant modification. The Executive Board has the responsibility to implement the single programming document, a paper containing multi-annual and annual programming conducted. However, the finalization of the programming document is subject to the final adoption of the general budget, and if necessary, it might be modified accordingly. The anti-fraud strategy that should be equitable to fraud risks and the adoption of its rules of procedure, including rules to avoid and manage conflicts of interest regarding its members, are also among the responsibilities of the Executive Board. It carries out the recruitment procedures for the officials of the authority, concludes the contracts of employment, and approves the relevant implementing rules to be brought into force for the staff regulations and the conditions of employment. The role of the Executive Director is also very important in the structure of the authority. He or she is a temporary agent of the authority with managerial duties and is under the obligation to remain independent from any government or other body. The tasks of the Executive Director are the daily management of the authority. The main responsibilities of the Executive Director are the implementation of decisions of the Executive Board, the preparation and application of the programming document, the drafting of a unified annual report regarding the activities of the authority, and an action plan according to the conclusions of internal or external audit reports, evaluations, and investigations by the European Anti-Fraud Office. In addition, the Executive Director is in charge of the duty to safeguard the financial interests of the Union by implementing preventive measures and drafting a strategy against fraud, corruption, and other illegal activities. In general, the Executive Director ensures that the authority is functional by taking all the necessary measures. The last body that forms part of the authority structure is the Administrative Board of Review, that is established in order to conduct internal administrative audits of the decisions of the authority regarding its supervisory powers, administrative pecuniary sanctions, or periodic penalty payments that might be imposed. The members of the above body are appointed by the General Board and have the obligation to remain independent and act in the public interest. Before describing thoroughly the tasks and powers of the new authority, it is emphasized that its main scope is to prevent money laundering and terrorism financing in the Union by enhancing supervision and improving cooperation between FIUs and supervisory authorities. The role of the new authority is not to substitute the national supervisors in relation to all obliged entities, but to outline their exercise of tasks and powers. The tasks and powers of the new authority shall be described within Articles 5 to 44 according to the above-mentioned proposal. In more detail, the tasks of the authority, as described in Article 5 of the proposal, are divided into 5 categories, depending to whom it may concern, meaning the internal market, the selected entities, financial and non-financial supervisors, and FIUs. First of all, the tasks of the authority regarding the internal market are monitoring emerging developments not only across the internal market but also in third countries, including the assessment of threats, vulnerabilities, and risks regarding money laundering and terrorism financing. Furthermore, the authority is in charge of collecting information resulting from its supervisory activities and the establishment of a central AML-CFT database in relation to the identified weaknesses. Some extremely important duties of the authority is monitoring and supporting the application of assets freezing, as well as the reinforcement of the cooperation and exchange of information between obliged entities and public authorities with a view to developing a common understanding of the money laundering and terrorism financing risks and threats for the internal market. The authority has the direct supervision of the selected obliged entities, meaning credit institutions, financial institutions, or a group of credit or financial institutions at the highest level of consolidation in the European Union, while its tasks include ensuring group-wide compliance according to the obligations applicable, pursuant to the relevant legal framework regarding AML-CFT. It also assumes the obligation to conduct audits and evaluations on individual entity and at group-wide level in order to identify possible vulnerabilities in the applied procedural strategies and arrangements. With a view to assessing the above risks and vulnerabilities of the obliged entities, the authority develops and maintains an updated system. Where a selected obliged entity does not comply with the requirements of European and national legislation regarding AML, the authority might exercise the following powers. First of all, the authority may demand the application of the relevant legal and procedural framework, a plan to rebuild compliance with supervisory requirements, including application of a specific policy. Furthermore, the authority may request the restriction of any business activity that can pose excessive risks for money laundering and terrorism financing, and also the implementation of measures to reduce the above risks in the activities, products, and systems of obliged entities. The authority may impose stricter measures to select obliged entities, such as administrative pecuniary sanctions or periodic penalty payments that are enforceable. Non-financial supervisors are considered supervisors in charge of obliged entities other than credit and financial institutions. Subsequently, the tasks of the authority with regard to financial and non-financial supervisors would be deemed, for the first one, to maintain an updated list of financial supervisors in the Union, and for the second one, to keep the same updated list for non-financial supervisors. Conducting periodic reviews in order to secure that all financial and non-financial supervisors have enough resources and powers to exercise their duties. It also conducts periodic evaluations on the above issues and facilitates the functioning of the colleagues of financial supervisors in the AML area, while assisting with convergence of supervisory practices and promotion of high supervisory standards in the same area. As colleagues of financial supervisors are considered permanent, flexible structure of international banks through which supervisory activities are coordinated. In the European Union area, supervisory colleagues also have a decision-making role. Moreover, the obligation of the authority regarding the non-financial supervisors is the coordination of peer reviews of supervisory standards and practices. In case of breach of the requirements applicable to obliged entities, the authority may request non-financial supervisors to carry out an investigation and consider if it's necessary to impose sanctions or take remedial actions. The financial supervisors may also notify the authority in case that a non-selected obliged entity does not comply with the necessary requirements, resulting in exposure to money laundering and terrorism financing risks. If the authority detects any significant breach of non-selected obliged entity, it may request its financial supervisors to investigate any possible breaches of the legal framework and consider imposing sanctions according to the applicable legal framework. The authority exercises tasks regarding financial intelligence units, such as supporting and coordinating their activities. In order for the FIUs to conduct joint internal and cross-border analysis, the authority assists to determine and choose the relevant cases. In addition, the authority has a duty to arrange, organize, and promote the carrying out of the joint analysis of FIUs, and also to facilitate the access of the FIUs to the information technology and artificial intelligence services and tools. Another very important duty of the authority is the development, contribution, and promotion of expert knowledge for tracing, analysis, and dissemination of suspicious transactions. The authority is additionally in charge of the tasks to draft regulatory and implementing technical standards that should be submitted to the Commission for adoption. Regulatory and implementing technical standards are considered technical documents that do not imply strategic decisions or policy choices, and their content is based on legislative acts. Finally, the authority publishes guidelines and recommendations for all supervisory authorities, FIUs, or all obliged entities, aiming to establish coherent, efficient, effective supervisory and FIUs-related policies. The goal is also to safeguard the common, uniform and consistent application of the European legal framework. With a view to exercising its duties sufficiently, the authority should pursue to cooperate with the European Banking Authority, the European Insurance and Occupational Pensions Authority, the European Securities and Markets Authority, as well as conclude and maintain close cooperation with OLAF, Europol, EPPO and any other AML-related authority, not only in the European Union but also in third countries. After the overview of the structure and the tasks of the new authority, one may come to the following conclusions. The ambition of the discussed organization is to ameliorate the total quality of AML-CFT supervisory policies applied in the EU. The above goal is pursued by both directly supervising a limited number of the riskiest cross-border financial sector entities and indirectly overseeing and coordinating national supervisory authorities concerning both financial and non-financial sector obliged entities according to the AML-CFT legal framework. Furthermore, the authority is aiming to achieve greater efficiency and cooperation between FIUs by implementing common templates for exchange of information and conducting joint analysis with FIUs. The above objectives, as a total, are designed to target to the efficient detection and prevention of money laundering and terrorism financing. The stronger supervisory policies intend to lead to deterrence and higher likelihood of detection of the illegal assets. Only with the adequate supervisory inspection is it possible to thoroughly apply the relevant AML obligations through the private sector. It is evident that the proposal under discussion for regulation is a step forward towards the battle against money laundering and terrorism financing. All the above-mentioned provisions shall address directly the different enforcement approaches of certain member states, circumvent forum shopping techniques by the obliged entities, and allow for a group-wide consolidated supervision. In addition, the new authority may undertake in the near future more tasks regarding AML-CFT issues of great significance, such as the use of cryptocurrencies and crypto assets for money laundering and terrorism financing. The authority might also envisage the supervision of freezing, seizure and confiscation procedures, especially in cross-border cases, but also the management and sharing of seized and confiscated instrumentalities, including the procedure of money laundering and terrorism financing. The establishment of the new authority that is in charge of tasks and powers regarding money laundering and terrorism financing can become the springboard for regulating and addressing all the existing inadequacies. Thank you.
Thank you, Victoria. Thank you for this very interesting presentation, and let me congratulate you on working exactly on this topic right now, and I know how complex is the content of the reform package, and you succeeded in presenting it in a very clear way. It is my understanding that we leave the Q&A session for the end, so I will now leave the floor to Dimitrios Nomikos. Dimitrios is a public prosecutor and currently a PhD candidate of the Democritus University of Tracha, where he is conducting research on the European Public Prosecutor Office federal and digital protection perspectives. He will present today offenses, added value or further complexity, lost in the labyrinth or back to basics.
Yes,
it's
it from the Greek mythology.
The floor is yours.
Okay. I'm very happy to be here with all these specialists and of course with all the professors of the Luxembourg University. Before starting my elaboration, I'd like to focus on two elements. Firstly, when talking about the ability of the European Union to intervene in the criminal matters, we should take into account, of course, all the basic values that we all know I mean the rule of law, the principle of subsidiarity, and so on, the judicial accountability and the political accountability. Secondly, when we are talking about this competence of the European Union to intervene in the criminal matter, we should have in mind that it is a result of a big compromise. There are two tendencies. The European Union has its own legal entity. It wants to have more powers to intervene in the criminal matters. And on the other hand, there are the member states who hesitate to confer more powers to European Union because they think, they perceive that the criminal law is the hard core of national sovereignty. It's very crucial to have it in mind in order to analyze and to explain, because there are so many deficits in the EPPO regulation. The initiative proposal of the Commission was very innovative, very federal. But during the negotiations, we had 2 yellow cards, and finally, we had a collegial structure of the EPPO, which combines a lot of national and incremental elements. The actors. Of course, there is a multiple and well-organized system in the European Union field, a combination of union bodies and entities. There is no hierarchical relation among the entities. The whole structure is governed by the principle of complementarity. There is a system comparison, exchange of information under the common aim, and it is the protection of financial interests of the European Union. Olaf, Eurojust, Europol, EPPO, and European Court of Audit. As concerning the added value of the EPPO is the consequences of the necessity to protect by the effective means of criminal law the European Union budget, the European Union common market, and the European Union financial policies. Besides this empirical practical choice, we should focus on the aims of the European Union integration as they are laid down by the specific articles. The main goal of the EPPO is to reinforce the confidence of the European Union citizens and the taxpayers in the integration process. As concerning the other bodies, Olaf, Europol, and Eurojust have diachronically proved their utility because of their specialization and deep experience in the fight against fraud. The provisions in the treaties and the new regulations for Olaf and Eurojust empower the equal and complementary role with regard to the EPPO and strengthen their relation on a common basis. All these agencies have not been absorbed by the EPPO. They are perceived to be equal partners, and they all cooperate under the common aim. Because a big discussion, the EPPO should or could absorb all these agencies. It's an open matter. The final status of the EPPO is ambiguous because it's a result of a compromise, because of the many insertion of national and incremental elements. The adoption of the collegial structure of the EPPO is not compatible with the supranational mission of the EPPO. The initial proposal of the Commission, it didn't have the collegial structure, I think. The justification of the added value of the EPPO was the deficiency and the unwillingness of the national actors to protect the financial interests of the European Union. A posteriori, it seems paradox to rely on the national authorities in order to fulfill the task of the protection of the supranational interests. The multi-level construction of the entities in the PIF sector and the multi-division of tasks are perceived to be bureaucratic and result in confusion and delays. All this personnel, diversity of contributing factors, and exchange of information need effective administration. Occur irregularities and bring obstacles to the coordination. Several times there are conflicts of jurisdiction and overlapping of competence, disbelief and antagonistic relations. Okay, let's specialize as concerning the principle of proportionality. The human dignity and the fundamental rights are endangered because of the enlargement of the peace sector and the ability of the EPPO to impose intensive measures of procedural enforcement. The position of the suspect is disanalogous vis-à-vis the large and well-organized system of the European Union to fight the fraud. As concerning the principle of foreseeability, the absence of common sanctions and the different applicable law, procedural and substantive, result in vagueness and uncertainty. The material competence of the EPPO derives from the Article 26 of the Treaty for the Functioning of the European Union and needs to be translated into concrete offences to be adopted from the PIFTI directive. That's why that 22, paragraph 1 of the EPPO regulation is a kind of a dynamic blanket criminal law provision, contradicting to the principle nulle crimen sine lege. As concerning the principle of subsidiarity, the member states have transferred criminal competence to the European Union, but the European Union actually has a symbolic competence, finally, in this field because of the insertion of so many intergovernmental and plurilateral national elements in its operational structure. The applicable procedural law is predominantly national law, and even the substantive criminal law is associated with the final choices of the national legislator. Principle of confusion, phenomenon of competence creep or stealth competence. Serious legitimate concerns have been expressed for the ancillary competence of the EPPO. Article 22, paragraph 3 of the EPPO regulation. The EPPO's broad material competence is problematic with regard to the principle of subsidiarity and proportionality. Any extension of the EPPO's competence rational material meets with the requirement of the foreseeability and the legality of criminal law and penalties, and access crucially to determining the protection of the affected individuals under the nebis in idem principle. That's another expression from the Greek mythology. The EPPO has been characterized as a Trojan horse for the competence of the European Union to intervene in the field of criminal law. Finally, the main law of the working relies on the DPOs by using the procedural national law and by means of horizontal cooperation. Moreover, in contrast to the view of the Commission for a single legal area, the EPPO would use instruments of mutual recognition. The EPPO regulation lays down 3 levels of protection encompassing the whole arsenal that the legislation of the European Union could offer. This multiple system of protection is laid down in that 41 of the EPPO regulation, and it is characterized by a comprehensive combination of national and supranational instruments aimed at the most adequate protection. At a first glance, this approach seems to be generous for the right. That's true. There has been expressed some criticism about it. There is legal uncertainty because of the vague legal framework in the PIF sector, the conflicts of jurisdiction between the European Union agencies, the bureaucracy, the phenomenon of overlapping of the competence of the European agencies, and the lack of a uniform and a divided procedure. From a defendant's perspective, the right of effective defense is at stake as a result of the legal uniformity, the multiple character of the administrative and criminal investigation, the diversities of the legal framework in the member states, the different applicable law, and the complexity of the multiple and proliferated structure and functionality of the PIF sector. The principle of equality of arms, as concerning the set, is vis-a-vis the numerous and powerful European Union agencies in a strange and unknown supranational forum equipped with strong mechanisms of law enforcement. The large system of data transmission and exchange of information in the European Union field could be a serious data breach and infringement of rights. The same centralized model of the criminal procedure governing the EPPO activities has a lot of risks for a balanced and coherent procedure as a complex mixture of different legal systems. This complexity is being strengthened in the case with transnational characteristics. The model of complementarity of the Art 41, based on the system promoting the most favorable treatment, could be dysfunctional and ineffective for the individuals because of its complexity, mixture of national and European Union legislation, and the multitude of applicable national provisions, legal uncertainty and non-foreseeability, different levels of protection within the same criminal procedure, even when it refers to the same right. Legal uncertainty perceived more pronounced in cases where the EPPO can act in multiple jurisdictions. The Art 26 of the EPPO regulation empowers the EPPO to choose or to switch the national forum on investigation and prosecutions under specific conditions. The option for the EPPO to change the forum or to choose the forum, it's the so-called forum shopping, is contrary to the principle of foreseeability and constitutes a serious obstacle for an effective defense. The EPPO regulation does not mention the rights of the European Convention on Human Rights. It has been criticized that symbolically and explicitly a reference to European Convention on Human Rights could have been welcome. Of course, the relation among the Charter and the European Convention of Charter is open. It's under discussion. Maybe there would be a provision later. Political accountability. All the agencies in the PIF sector are subjected to political accountability. As concerning the EPPO, the Article 6, paragraph 3 of the EPPO regulation prescribes that the EPPO is accountable to the European Parliament to the Council and to the Commission for its general activities, and that it shall issue annual reports in accordance with Article 7. As concerning the judicial accountability of the EPPO, the EPPO regulation relies on national courts and not on the Court of Justice of the European Union for the review of procedural acts of the EPPO that are intended to pursue the legal effects vis-à-vis third parties in accordance with the requirements and procedures laid down by the national law. Of course, there are some exceptions, as they are provided in the regulation. There is a negative assessment. This system is perceived as not compatible to the treaties. It's not a federal solution. A federal instrument prosecutes, and the judge is not a federal, it's national. In my opinion, the arbitration of the majority of the EPPO cases to the national court is considered to be more efficient and practical. The national judges have deep knowledge of the national procedural law imposed by the European delegated prosecutors, and the defendants are more familiar with the national judicial system. Okay, let's conclude. This is my outlook. This is my personal view. The EPPO has a pro-national federal character and symbolizes the Europeanization of the criminal matters, and it outlines the utilization of the criminal law for the aims of the European Union with a constitutional and deontological approach. The concept of the EPPO is connected with the prestige of the European Union and mirrors the willingness to protect its financial interests, but its own flagship. Doubtless, the EPPO has infant constitutional added value as it represents the supremacy of the European Union and goes one step forward for the integration and the protection of the money of the citizens of the European Union. Its status is based on strongly independent and on comprehensive judicial and political accountability. The added value of the EPPO is associated with the rule of law and the other principles of the European Union, the protection of the fundamental rights and the procedural safeguards. The PIF investigation, especially the EPPO, has been subjected to serious criticism based on factual deficits and constitutional matters as elaborated above. Focusing on the traditional perspectives of the traditional criminal law, it is perceived that there is a plethora of shortcomings. However, we should assess the PIF investigation by using the suitable criteria, which are connected to the sui generis federal character of the European Union, the goals of European Union integration. From a federal perspective, all this identification is necessary to protect the existence of the European Union. It has a great symbolic meaning, and it's a step ahead of the European Union citizenship. This is the core of the added value of the PIF identification. The hesitation of the member states to confer powers to the European Union and the insertion of national and incumbent elements are the factors that cause malfunction to the European Union PIF agencies. In order to safeguard the added value of the PIF identification, we should adopt more clear and cheaper federal models like the previous corpus juris. Federal budget needs to be protected in a federal way by clear federal means. Of course, it seems impossible to adopt a model like the corpus juris because we have to rebuild the whole system. But we could adapt solutions in order to harmonize the legislation among the member states, and probably we could use some other legal basis to do this, not only the 22 and the 23 of the Treaty for the Function of the European Union, possibly the 26 of the Treaty for the Function of the European Union, and it is, of course, the Article 225, in order to harmonize and to build the faith among the member states. Thank you, that's all.
Thank you. I think you gave a lot of thoughts to the presentations of the REACH program of tomorrow that will be mostly dedicated to the European Public Prosecutor Office, listing all the many problems that the current regulation is affecting the current regulation. I just noticed that I'm looking at John here on the front row of how accepted it is to talk openly about federal, and this is somehow a change that I think has to be absolutely welcomed. And thank you so much for respecting very, very carefully the time allocated to your presentation. And it's now my pleasure to leave the room to Athanasia Dionysopoulou. She's assistant professor at the University Kapodistrian of Athens. She holds a PhD doctor from the Johann Wolfgang Goethe University of Frankfurt. And she will present on the PIF offenses, who investigates and prosecutes, and the scope of competencies of the European Public Prosecutor Office. Please, the floor is yours.
Thank you. I would like, first of all, to thank the University of Luxembourg for the invitation. I'm very happy to be here with you. In my paper, I will present an interpretation of two provisions of the regulation on EPPO under the view of the legal pluralism. So, yes. In EPPO regulation, the interaction between EU and national law is of utmost importance. One of the key points in which this interaction manifests itself is the initiation of the investigation by EPPO and the reallocation of cases within EPPO in cross-border cases. And so the present paper focuses on these two points. The reason for focusing on these 2 points are the following. First of all, decisions concerning investigation and prosecution of a criminal offense are being made now by a supranational institution and do not fall under the absolute discretion of the national authorities in PIF offenses. These decisions are also being shaped by multi-membered bodies, such as permanent chambers, following rules that lie out of the control of national judiciaries. Additionally, the decisions by the permanent chambers concerning the reallocation of cases already investigated by EPPO are equally crucial, since they determine the national law which will be applied for the gathering of evidence, the relevant rights of the defendant, the simplified procedures, and the dismissal of the case. Now, a few words about the conceptual framework which is on the basis of my interpretation. The EU law has been viewed from different perspectives, manifested in the various theories that emerged in political science to explain the process of European integration. Even though these theories do not constitute a normative analytical framework, their influence on understanding of the EU law has been substantial, particularly the distinction between functionalism and intergovernmentalism. This dichotomy has survived during the different phases of EU integration and has evolved to the newest versions of liberal intergovernmentalism and rational choice institutionalism and neo-functionalism. The EU integration theories contribute to a more profound understanding of the forces driving the European integration by tracing, each one from its own point of view, the justification for the content of EU law provisions and the consequences of each legislative proposal or act on the allocation of power between the national and supranational actors. In this sense, they provide useful insight into various elements in EU law. For example, decision-making rules in the Council of Ministers may be regarded in the view of the rational choice institutionalist analysis, which considers states as primary and central actors in EU integration and assumes they behave as utility-maximizing rational ones. Although each EU integration theory highlights from its perspective various aspects of EU norms, it is still not a legal tool for interpretation. When a legal analysis starts from intergovernmental or a functionalist perspective, it is bound to follow the respective line of reasoning and, as a result, perpetuates the dichotomy. Not ignoring the different perspectives of the theories on EU integration, it would rather be more fruitful to focus on the approaches, the relationship between national and the supranational legal order, such these have evolved in the constitutional framework of constitutional pluralism. This framework emerged in the aftermath of the Maastricht decision of the German Federal Constitutional Court and was based on pluralist legal theory, according to which the relationship between legal systems is pluralistic and interactive. Over time, under the same in nominal terms framework, very different concepts have gradually been elaborated. This paper adopts the approach based on the distinction between legal order and legal system. In this scheme, legal system consists of law and institutionally framed legal practices, such as lawmaking, adjudication in courts, and legal scholarship, whereas legal order refers to the law itself. We may have a pluralism of legal orders when more than one legal order claims authority over the same legal space. That is exactly the concept in which EU law and national law are operating. EU and national legal orders are autonomous, but they form part of the same European legal system. In each member state, two legal orders claim authority, the national and the EU. Their relationship is interactive, meaning first that each legal order recognizes the plurality of equally legitimate claims of authority made by other legal orders and adjusts these competing claims in accordance with a minimal set of discourse principles, the most important of which is the engagement in the coherent construction of the common legal system. The dialogue between the legal orders requires that each one distances itself from its exclusive perspectivism and moves to the interperspectivism resting on a shared common deep culture, which in our case is the European legal deep culture as manifested in the values shared by all national European legal orders. It is in this pluralistic approach that various provisions in the treaties, particularly in the area of freedom, security and justice, are being interpreted as mechanisms of managing pluralism. By these, we mean they describe procedures, institutions and practices which may be considered in their function as means or mechanism to manage conflicts and generally to define the interaction between the different legal orders who claim authority in the same legal space. Acknowledging this function does not furnish concrete answers to conflicts of laws, but allows space and provides criteria by which these may be managed. The quality of this criteria relates to the extent to which this space is provided and if it facilitates discourse among the legal orders. I'm now coming to legal pluralism in the area of freedom, security and justice. The first normative level on which the interperspective dialogue between the national and the EU legal order is based is, as I've already mentioned, the common deep legal culture expressed in the rule of law and protection of fundamental rights, as well as human dignity, freedom, democracy and equality as foundations of the EU legal order. The area of freedom, security and justice on a descriptive level is established to facilitate the free movement of persons while ensuring the safety and security of people in member states. Security is ensured by measures concerning external border controls, asylum, immigration, and safety by preventing and combating crime. EU competence for the policies in this field is governed in particular also by respect for the fundamental rights as set out in the Charter, which has the same value as the treaties and as the result of the constitutional traditions common to the member states and by the different legal systems and traditions of the member states. The second normative level is the mechanisms of managing pluralism themselves. These are various concepts established in the EU treaties and applied in the area of freedom, security and justice, such as the concept of shared competence, complemented with the principle of subsidiarity, the principle of sincere cooperation, and the directives as forms of legal acts, which may be viewed not only as legislative options concerning the institutions and the functioning of EU legal order, but also as means to regulate the interaction between the different legal orders. Other mechanisms lie in the EU decision-making process, namely the ordinary legislative procedure by which directives are adopted in the policy areas of freedom, security and justice, including the emergency brake and the composition of decision-making bodies. Coming now to these specific notions, starting from jurisdiction, if seen from a pluralist point of view, it is a meaning-producing cultural product which reflects and constructs social conception of space, symbolizes community membership, and opens space for norms that challenge sovereign power. The subsidiarity principle, in its traditional meaning, seeks to push authority for decision-making down to the smallest unit of governance that is feasible.
However, as a pluralism concept, it aims to ensure dialogue among multiple legal communities, leading to increased acceptance by each. The principle of loyalty or sincere cooperation entails that EU and Member States assist each other in carrying out the tasks following from the treaties, and that Member States ensure obligations arising from treaties and refrain from any measure that would jeopardize the attainment of the Union objectives. In its pluralist conception, it provides a most general discursive mechanism for managing conflicts in various areas, such as shared competence or transposition of EU law in national legal order. Directives, as contrasted to regulations, are in the legal pluralist conception forms of law that create different legal objects upon the same social objects as the national forms of law. As a result, different legal orders operating on different scales translate the same social objects into different legal objects. Since they operate simultaneously in the European legal system, they relate to each other. This relation may be described as interlegality and is being manifested in the transposition of directives into the national legal order, which uses a different scale, projection, symbolization for the same legal objects. The understanding of this relation contributes not only to the correct transposition, but also to the interpretation of both national and EU law. These mechanisms are particularly important in the area of freedom, security and justice, as jurisdictional rules ascribing competence to the EU function as alternatives, challenging the sovereign power of member states, even if the EU has no enforcement power, meaning, for example, no power to inform material acts of enforcement, because in reality, EU has immaterial enforcement powers. Thus, when EU exercises its competence in the area of freedom, security and justice, it affirms the fact that the policy field it regulates belongs to the supranational level, and the way it is regulated should not be left at the discretion of each member state and as a result in its own authority. The conditions under which this competence is exercised in the shared competence scheme include primarily the principle of subsidiarity, which creates a discursive tool for all legal orders to accept the exercise of competence and ultimately contribute to its essential acceptance. This tool is reinforced on a procedural level by the participation of national parliaments in the control of the subsidiarity principle and by their power to oblige the organ from which the draft legislative act originated to review the draft and justify its final decision. Whereas the directives are concerned, the concept of symbolic cartography of law, which contains the notions of scale, projection, and symbolization, may be used to clarify the extent of the margin of discretion left to national law and thus provide criteria for assessing the quality of implementation in the national legal order. The decision-making bodies also constitute discursive place because their decisions, legislative acts, incorporate all national legal orders perspectives as all member states are being represented. The emergency brake procedure, as an alternative path of legislative procedure, is also a particular mechanism of managing pluralism in the area of freedom, security and justice that aims to ensure that fundamental aspects of each national criminal justice system have been taken into account when adopting a directive. Coming now specifically to the EPPO and to the role of the PIF directive. The choice of adopting a directive on the legal basis of Article 83, paragraph 2 of the Treaty of Functioning of EU has the consequence that establishes only minimum rules, leaves room for discretion in national law when defining the relevant offences. Taking into account that the PIF directive defines not only fraud but also other offences against the financial interests of EU, the margin of discretion of national law applies to those as well. This discretion extends also to threatened penalties, since the PIF directive adopts the maximum minimum system contrary to the initial proposal by the Commission. As the scope of competence of EPPO defined in Article 22 of the regulation falls not only fraud but also other offences against the financial interests of EPPO, for example, money laundering, bribery, misappropriation of funds, the choice of the directive as a legislative instrument led to compliance issues in the national law of several member states. This is an anticipated situation, since following the pluralist approach, the different national legal orders operating on different scales translate the same social objects into different legal objects. In our case, the social objects, which are the contacts in their factual dimension, have to be translated into national criminal provisions. The quality of this transposition, which is an essential condition for interlegality, depends upon various factors in each national legal order. The way it affects the EPPO competence in cross-border cases will be examined in the following. When EPPO exercises its right of evocation or initiates an investigation and two or more member states have jurisdiction for a particular case, which is a horizontal division of competence between European delegated prosecutors of different member states, the criteria for the permanent chamber to decide in which member state the investigation will be conducted are where the focus of criminal activity is, or if several connected offences within the competence of EPPO have been committed, where the bulk of offences has been committed. A deviation from that rule is justified when the permanent chamber takes into account, in order of priority, the place of suspects or accused person's habitual residence, nationality of the suspect or accused person, and the place where the main financial damage has occurred. The use of criteria such as the focus of criminal activity or bulk of offences for selecting a national legal order implies that it should punish all contacts and consequently has fully transposed the directive, the PIF directive, of course. So if acts have taken place in different legal orders and are not punished in all of them to the same extent, the European delegated prosecutor of the member state which punishes all the acts will be instructed to initiate investigations. The threatened penalties or the period of limitation do not play a substantial role at this stage. If the permanent chamber decides to deviate from that rule, it's obvious that it has to weigh the national law of the member state where the bulk of offences has been committed and in conformity with the PIF directive against the national law of the member states either of suspects or accused persons' habitual residence, nationality, or where the main financial damage has occurred. In case of inextricably linked offences to the offences against the financial interests of the EU have been committed, these are not part of the PIF directive, of course, such as forgery, connected with money laundering of proceeds of EU fraud. Since EPPO has competence for these as well, under the conditions set out in Article 25, paragraph 3 of the regulation, the scope of national provisions defining them should also be taken into account by the permanent chamber to select the EDP. The national law which implements the PIF directive affects EPPO decision to reallocate a case to an EDP in a different member state during the investigation phase and before EPPO decides to prosecute the case. In this case, it must be in the general interest of justice, as the wording of Article 26, paragraph 5 of the regulation. The criteria for assessing the general interest of justice are not mentioned in the regulation, as this term describes the interlegality, namely the interaction between different legal orders that have jurisdiction in each particular case. To define the interlegality, our starting point is the legal basis of EPPO, anchored in the area of freedom, security, and justice, and the core principles in the pluralist perspective are the rule of law and the protection of fundamental rights, together with guaranteeing the internal security by combating crime. That means that the decision should take into account not only the national law concerning limitation by time and threatened penalties, but also the fundamental rights of the suspect by assessing the effect it would cause on them and by weighing it against the compensation mechanisms that are in place in the national procedural law of the member state involved. Moreover, the criteria of Article 26, paragraph 4 of the regulation should also be considered regarding residence, nationality of suspects or accused, and the place where financial damage has occurred. The procedure under which this decision will be made in the permanent chamber is being described in Article 50 in the rules of internal procedure. And now I'm coming to the role of the permanent chambers and I'm finishing. The next step is to examine the procedural aspect of the above EPPO's decision from a pluralistic perspective. When EPPO decides to initiate an investigation and two or more member states have jurisdiction, it's the permanent chamber that instructs the EDP in one of the member states by following the above mentioned criteria. Since permanent chambers are decision-making bodies in which European prosecutors from different member states are participating, they constitute in pluralist terms a discursive space in which the perspectives of all legal orders having jurisdiction may be taken into account. This also applies in reallocating a case where decisions are also taken by the permanent chamber following the procedure in Article 50 of EPPO's internal rules of procedure, which sets the conditions for the dialogue between the different legal orders. And now I'm coming to my concluding remarks. I have tried to interpret the provisions of Articles 26, Paragraphs 4 and 5 of the regulation as mechanisms of managing pluralism, and to my opinion, they constitute a discursive space in which all relevant national legal orders are being taken into account. The interpretation of the criteria takes into consideration the different extent of national law's conformity with the PIF directive. Differences are part of the interaction between EU legal order and domestic provisions of each national legal order, and the provisions of the regulation refer to criteria and institute procedures in a way so, under the legal pluralist approach, they can be applied and manage conflicts between the national provisions and the EU ones efficiently in the European legal system to which they both belong. Thank you very much for your attention and patience.
Thank you, Athanasia, for this very interesting reading of the mechanisms, in particular of 2026-4, that received a lot of criticism. For sure, that is a space for development. It's a sort of laboratory, and I'm not always sure that they consider all the criteria that you mentioned, but for sure, let's say that legal pluralism is a very, very interesting key to read the debate that is taking place currently at the European Public Prosecutor Office. According to the schedule that I've received, we have a few minutes for a couple of questions, but I received the order that at 6:30 the session should be closed. Yes, please. I think it's for, are we connected with WebEx, yes. No? Yeah, so it's necessary.
Thank you. I have a question for Professor Victoria, I believe.
I'm not professor, but...
Doctor? All right. Well, regarding this launch of the package of the European Commission on these 4 new proposals, one of them including, of course, the AMLA, the European legislator, of course, expects some consequences that relate, of course, with a more effective fight of money laundering. But in your opinion, which unexpected or unintended consequences could result from the implementation of these new proposals regarding, for example, new technologies such as, the cryptocurrencies? Maybe users will seek for more anonymity enhanced features of these cryptocurrencies, or I mean, in your opinion, which unintended or unexpected consequences could be derived from this, and of course, which would be the role of the AMLA that it would play in this regard?
Thank you for your question, and thank you for the observation, because I studied the AMLA, only the authority from this package, only the new authority I'm studying in this presentation, and what I've seen, and in my opinion, they don't. There's no mention in the word cryptocurrency or crypto assets, and that this is. I think that there is. They don't know how to do it, to say this, and we have seen that from the 6th AML regulation. From the 6th AML directive, that only then they insert the cryptocurrency and crypto assets, and we still don't know how this is going to work. So I can't say anything yet. we have to see how this will work. And we have to remember that the authority will be established in 2023, and we aim to start most of its activities at 2024, and act and begin to function at 2026. So until then, there are many things that we will see, and probably they will take into consideration. Thank you.
Yes, please. May I ask you to state your name just for the debate, please?
Absolutely. My name is Chad. I'm a German qualified lawyer, and I have a question on to Professor Leonie Sopru. Excuse me if I pronounced that wrong.
It's okay.
And it's on the reallocation of cases. You mentioned, in my opinion, very correctly that the rights of the suspected person need to be taken into consideration when doing so. From a defense perspective, how would you do that? So if I have a client and that case might be allocated somewhere, how can I voice my concerns about whether this should not happen or whether this should happen?
Well, as we know, as we all know, the judicial review of such decisions may only be performed in the national jurisdictions. So there's no centralized judicial review of these decisions. That's why I have tried to provide with criteria when these decisions are being made. To my opinion, only in the national, according to the national law, the execution of these decisions may be challenged, but not on the EU level. That's true. But I've thought a lot about it. I've thought a lot about it if it would be meaningful. If such decisions would be challenged on EU level, on an EU level. Well, taking into account that actually the EPPO has no real enforcement powers, and I've mentioned that during my presentation. It's only, I would say, in a way natural that the judicial review is being performed in the member states according to national law. It would be, I think, much more complicated. It would demand the adoption of another system of organizing EPPO if judicial review would take place on a supranational level. Thank you.
Thank you. Maybe we have time for a last question. It seems that you satisfied all the curiosity in the room, and considering that you already followed a very, very long and intense afternoon of this conference, I think it is time for us to close. We will see each other again tomorrow morning, 9:30, but this time it's not here. It's
the hemicycle.
At the hemicycle. So enjoy this evening in Luxembourg. Thank you.
I was losing my board.
Oui, on est.
Ok, donc je n'ai pas besoin de les reprendre. Ok, ça marche. Bon, bah, pas de soucis, à demain.
À demain.
Allez, bon courage.
Merci.
So we see 7 o'clock.
7:30.
7:30, okay, better. So,
Yes, yes.
Thank you for all.
You're welcome. You're welcome. We will meet each other better tonight. Yeah. Take care. 7:30. Seregi. Yeah, Silvia is not coming.
But you would like to
We can already start to talk to everyone. Please have a start.
Shall I check that it's fine?
Otherwise they have to pay and
Yeah, no, I can pay.
we're working on confiscation. And
Not yet.